has been overruled
registered.
and the text is changed because of the introduction of
Correct.
Now, interpreting this Dolia
Yes,
and the earlier judgment appears to be one way of doing it.
Yes, ma'am.
That the High Court or perhaps the court under Section 8, when it refers in a case which is a little nebulous,
Right.
where, prima facie there is an agreement, X is an agreement. But the court does not want to really finally hold there is an agreement.
It can then
device can be to actually expressly make it clear that we are doing it in this way. We will not take away your right
under 16.
Agitate it under Section 16.
Correct.
One that might perhaps hold the key
Yes.
to solving this problem as to in which case the parties are yet free despite a finding.
Yes, madam.
Or the second thing is the court should not go elaborately into it.
Correct.
You begin with that.
Right. Or if it is obviously not manifestly, if the court feels that this can be closed quickly, then the court can close it.
Matter is over.
So, my lord, it is really as.
So it really depends on what the court will really get to say.
Right.
First of all, understanding the limited nature of its jurisdictions at that stage.
My lord, the practical situation is this: your lordships are a court. The High Court is a court. Courts want to decide.
That's it.
That's the normal. So that's the normal, my lord. It's very difficult for the court to say.
What the court can do is
to step back.
The court say, step one, there is an agreement. It is in writing. It discloses that there is an arbitration agreement. Okay. X, Y, Z factors are urged against its validity, even against its existence.
Even existence.
The court finds that these are matters which are better gone into in a section 16.
Correct.
So there the court says there is an agreement. We leave it open to you to take all your contention in section 16.
The Alice in Wonderland case, my lord.
The real solution is the court may make it clear.
Court will make it clear.
Foreclosing your right under section 16. The matter will
in fact, your lordship, that clarification has to be given, my lord. In fact, in Praveen Electricals, that was specifically made clear.
You have to enter the matter. You don't have to sit in for years together, like 11 years in Jammu and Kashmir, where you spoke about. I mean, it can be avoided if you have this.
My lord, it is basically something which is against the nature of the judge. The judge is there to decide issues. But here, my lord, the judge has to step back and leave it to somebody else. It goes against the judicial, my lord,
it's a change in law.
Nature.
The legislature has
the
text of the act, and therefore SBP has been overruled. We have to accept that. Unless we
have to accept that
is wrong.
We have
to.
Para
12, which appears to suggest that if once a court enters a finding regarding even the existence, there is a bar under section 16. That may not continue to hold good, but the care must be taken both in the exercise of jurisdiction under section 11, 8, and also making it clear appropriately in the order.
Lordships will clarify.
If that is done,
there should be no problem.
Clarify the whole thing.
There should be no, my lord, that actually happens in cases where it doesn't go to court. It happens, my lord. You appoint subject to this, and then you go ahead. And you first preliminary point you raise, it is void, it is contrary to competition law, it is etc. etc.
As they would say that the cause of arbitration will be served even by those who stand and wait, not necessarily that by not adjudicating you are doing injustice.
Yes, my lord. In fact, this is a case where the court need not
step back.
Should well, it's difficult. It is difficult because
by tendency,
and my lord, if your lordship sees some injustice, then it is very difficult to tell a court, now you don't look at it, my lord, please send it to the arbitrator. That is something which is, as my Lord Justice Bose said, the case of the piece of paper with the arbitration clause. The court wants to step in. So, my lord, there, of course, there's a Consumer Protection Act.
Praveen was a case where they found that there's no existence. Yet, Supreme Court did not disturb because, there are a lot of evidence.
A lot of evidences. It was a concocted agreement. It seems like
that Alice in Wonderland analogy came in only because of the situation prevailing there.
That's right.
It was not in existence.
Not in existence.
I have forgotten how to speak English.
That's right.
See, if you do online transaction, the offer and acceptance is complete, then the goods arrive, and in that product description or something, there is inserted an arbitration clause.
Yes,
That is post-contract.
post-contract. Well, no, there, of course, there is another point. That's a consumer
Yeah,
dispute.
we don't want to engage in that, but
There, well, not then that it may not be arbitrable at all because it may be a consumer dispute. There are
somebody may like to go to a suit court also.
somebody may like to go to a suit.
Then that Section 8 question.
Section 8 question will come.
But we must not get derailed too much because here we are on a stamp.
We are on a very limited.
So therefore, I mean, otherwise
Otherwise, this discussion
go
will
on
not
and go on.
will continue. Well, let me then just place 34 and 41. SOR. Don't place SOR.
One more thing, see, at the time, the decision in SPB was rendered.
Correct.
The position of Section 6 was different.
6 was different.
It was totally different.
Totally. Totally. Well, not in fact, therefore 6 was interpreted in that particular way.
And again, then Section 7 was also there. I mean, subsection 7.
7 is still there. Manoj.
But then,
7 is still there. Unfortunately, it's there. 7 is still there.
by the president, after 6B, it is 8.
No, that may be in the 2019 it has been delayed. 19 it has been delayed. 7 has gone in 19. It is still there.
Up to 9. That is the Act 33 of 29.
That has not been notified, that portion.
That is also.
That's
Just like.
so, Malord, it is unclear what the law is. Some portion is deleted, some portion is not notified. There is a very nice chart.
In SPB, Section 7 was also taken into consideration.
Yes.
But Section 6 at that point of time, it was totally.
Totally.
But still in paragraph 15 of SPB, there is a finding that that decision is judicial, in excess of judicial power.
Yes, Malord. That's where
It's
the
not administrative.
it's
Paragraph 15 very categorically held that it is in exercise of a judicial power.
Malord, I just want
Paragraph 15.
right. Malord, may I just now show Malord? Yeah, we've shown section 16, Malord. The Lordship will just see 2 more sections, and I'll just show the Malord, the law commission. At 4 and 45. My lord, just see before the law commission. Please see. I just complete the act, my lord, and then come to the law commission, which will perhaps assuage some of these issues. My lords have seen 16. Just complete it. Please come to 34 for me. Yes. Ayavati also.
Followed by in
Praveen.
Praveen and
Reject. By Vidya Jolia. That seems to
that appears to sort of crystallize the law, apart from overruling. Instead of the limited nature of stated level.
right. Yes.
See
Yes.
whether it exists. That's it.
My lord, Vidya Jolia, little bit of fine tuning, little bit may
A
have.
little bit.
It may have.
You're right.
My lord, just see 34. 34 is a provision, my lord, which is effectively a copy of the model law. And the reason I am showing 34 is, my lord, 34 has 2 limbs. 34, my lord, 2A and 34 2B. 34 2A is a defense raised by a party. 34 2B is something that the court can find by itself. There is a distinction, my lord, normally people do not notice. Then your lordships will note that 34A has 5 different subheads. Your Lordships have 34.2A. Arbitral award may be set aside by the court only if the party making the application established so and so, one party is under incapacity, etc., etc. There are 5 subheads of 34.2A.
2019 5 SCC also. Yeah.
34.2A has 5 subheads and 34.2B effectively has 2 subheads. My lord, each of them are different, and there is a reason I am raising this, my lord, because it has some relevance to Vidya Jolia also. My lord, may just see 34.2A2. 2A2 says the arbitration agreement is not valid. So it is invalid under our law. That is one situation where the agreement itself is invalid. Validity may possibly also include existence. Then, my lord, please contrast it with Roman 4. The arbitral award deals with a dispute not contemplated within the terms of submission or contains matters beyond the scope. My lord, this is little different. 2 is validity of the clause. 4 is a dispute which does not fall within a clause. My lord, this may be relevant for Vidya Jolia. Then, my lord, a different heading is now 2B1. 2B1 is the subject matter of the dispute is not capable of settled by arbitration. So there is subject matter arbitrability. This is the issue, my lord, which was raised in Jolia. Namely, that even if there is an arbitration clause on the face of it, but in fact it is barred by landlord tenant. And then, my lord, the next heading is public policy. So public policy is treated differently. Dispute not capable of arbitration is a matter only for the court to decide, because the court will ultimately, even if there is an award, even if nobody raises it, court will decide. So, my lord, this is 34. Your lordship will just note this. And, my lord, 45. The relevance of this, my lord, I'll come to later. But 45. 37. Conditional appeal. We'll leave it. 37 is the appeal provision, which shows only there's a conditional appeal in 16. And then, my lord, 45 is in part 2. My lord, I am only, this is actually under the New York Convention. We are stricto sensu not concerned with. But it uses the expression unless it prima facie finds that the said agreement is null and void, inoperative or incapable of being performed. So, my lord, if your lordship steps back and now looks at the Arbitration Act in entirety, Section 8 uses the word validity. Section 11 uses the word existence. Section 16 uses the words existence, validity, jurisdiction. Section 45 uses the word null and void, which means validity, inoperative, incapable of being performed. In different sections of the same act, very different phrases are used.
Have you given this
I've given
description in your note?
I've given the description at page. My lord, we will have to give some meaning to the text also. So where existence is used, please use existence. Where existence or validity is there, please. So, my lord, after all, the legislative, my lord, intent is reflected best from the language. So, my lord, this is so far as the act is concerned. Now, my lord, the most important amendment came in 2015. And again, my lord, we are going away slightly from stamping, but it has some relevance. Please now see the Law Commission report, which has been now, my lord, referred to in n number of judgments. There are 6 or 7 paragraphs. I would request your lordships to have a look at that. My lord, this is in Roman part 4, put it in the 4th word. This we can leave. I have given references to the statement of objects and reasons of each of the acts, 96 Act, 2015 Act, 2019 Act, what are the relevant? I'm not going into it. It's there in the note. No? I'm curtailing this. The Lordship will straight away come to the 246 Law Commission. And please note, my lord, in this volume, pages 22 to 27, 49 to 51, and 52 to 55.
Volume.
Good.
Just repeat these pages once.
22 to 27, the main discussion, 49 to 51, and 52 to 55. Because this is the legislative background to the bringing into existence of 11. My Lord Justice Rastogi has got this volume.
We have volume 4.
Volume 4. My Lord, it's the report starts on page 1 and the relevant pages are 22 to 27, which are the main pages. My Lord, 22 starts. I'll just read a few portions, my Lord, just to put this in perspective. Delays in court before the arbitral tribunal investment treaty race. My Lord, this refers to that White Australia case. Judicial intervention in arbitration proceeding adds significantly to the delays in the arbitral process and ultimately negates the basis of arbitration. Two reasons can be attributed. First, the system is overburdened with work, not sufficiently efficient, disposed cases, especially commercial cases, speed and dispatch. My Lord, this is really a reason which is beyond my Lord, us at the moment. Secondly, the bar for judicial intervention, despite the existence of Section 5, consistently been set at a low threshold by Indian judiciary, translates into many more admissions cases in court arise out of related acts. So, my Lord, 22 identifies two problems. 23, your Lordships will skip, which is the wider problem. My Lord, we are not concerned with this at this stage. 24, two further sets of amendments proposed. First, it is observed a lot of time is spent for appointment of arbitrators, very threshold of arbitration proceedings. Applications under 11 kept pending for many years. In this context, Commission has proposed a few amendments. Commission has proposed changing the existing scheme of the power appointment being vested in the Chief Justice of the High Court and the Supreme Court, and has expressly clarified that delegation of power appointment as opposed to finding regarding existence nullity shall not be regarded as a judicial act. This will rationalize law and provide greater incentives to the High Court to delegate the power of appointment to specialized. So, my Lord, this is one recommendation. 11.7 recommendation, my Lord, is also there. Then your Lordships will come straight away. So, this is by way of background. My Lord, the main paragraphs are 28 to 33. These are, my Lord, extracted in Mayavati also. But there is one paragraph, according to me, my Lord, 29 is the critical paragraph which will address large number of issues. May I read 28? The Act recognizes situations the intervention of court is envisaged at pre-arbitral stage prior to the constitution of the tribunal, includes section 8, 9, 11 case of part 1, section 45 in case of part 2.
Which one you are reading?
My Lord, para 28 at page 20.
Yes.
Yes. So, my Lord, it recognizes situations the intervention of court is envisaged at pre-arbitral stage. Sections 8, 45 and also section 11 relating to reference to arbitration appointment directly affect the constitution of the tribunal functioning the arbitral proceeding. Therefore, their operation has a direct and significant impact on conduct of arbitration. Section 9, solely for the purpose of securing interim relief, although having potential to affect the rights, does not affect the conduct of arbitration in the same way. It is in this context, Commission has examined deliberated work. Now, my Lord, 29. I rely on 29 as an understanding, my Lord, of all the provisions. The Supreme Court has had occasion to deliberate upon the scope and nature, italicized, of permissible pre-judicial intervention, especially in the context of Section 11. Unfortunately, however, the question before the Supreme Court, framed in terms of whether such power is a judicial administrative power which obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e. the scope of arguments which a court, oblique Chief Justice, will consider while deciding whether or not to appoint an arbitrator, i.e. whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and which of these it should leave for decision of the tribunal. So, my Lord, first, scope. What is the scope of 11.6? Second, my Lord, what was put to me by my Lord, Justice Ravi Kumar, nature of such intervention, would the court consider the issue on a detailed trial, whether the same should be decided finally or left for determination. So, my lord, these are conceptually two issues that your lordships will have to decide on 11. What is the scope, which is what we are actually concerned with. We are not concerned with, my lord, the second portion of nature of intervention. What is
32 and 33 you have read? Look,
30? No, no, I have read only 30, then 32 and 33.
please read that one.
32, I'm reading that one. I have only come to 29, my lord. Then after a series of cases, Supreme Court held that the judicial power underlying issues were clarified by Bogara. So, my lord, then 30 Bogara set out. Commission is of the view that in this context, same test regarding scope and nature as applicable to contest 11 should also apply 8 and 45, since the scope and nature judicial should not change depending on party intending to defeat arbitration agreement, refuses to appoint an arbitrator, terms of the arbitration, moves the proceeding before judicial authority. In relation, my lord, this is to answer the question which fell from the tribunal. In relation to the nature of the intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu versus Aksh Optify, my lord, 2-1 judgment in the context of 45, where the Supreme Court has ruled in favor of looking at the issue controversy only prima facie. Justice Sabharwal took a view, Justice Sri Krishna took a view, and there was a split verdict. It is in this context, Commission has recommended amendments to the Section 8 and 11 of the Conciliation Act. Scope of judicial intervention is only restricted to the situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Even this was not accepted by the legislature. Even this was not accepted. The legislature cut out null and void. It went one step further and said existence. But I actually, my lord, personally, my submission is that there is really not much difference between existence and validity. It may be that the word existence may also in some way cover validity. It is not merely that your lordships will see on a piece of paper an agreement is there. Maybe some inquiry will have to be there. Is there some consideration? Is there something will have to be said? So, my lord, the recommendation was exist, null and void. Inoperative, incapable of being performed, not included. So, existence and null and void. Similarly, my lord, insofar as nature of intervention is concerned, recommended in event court is prima facie satisfied against the argument challenging the arbitration. It shall appoint the arbitrator, refer the parties to arbitration. Amendment envisages the judicial authority shall not refer only if it finds that it does not exist in arbitration agreement or it is null and void. If the judicial authority of the opinion prima facie arbitration agreement exists, shall refer the disputes, leave the existence to be finally determined. However, if the judicial authority concludes the agreement does not exist, conclusion will be final. So, my lord, this was the understanding in Shinetsu, and this is how it was. And, my lord, the amendments which were suggested are there. So, this is, my lord, the critical part of the report is paragraph 28 to 33.
Para 10 also, I mean, after para 10 we are reading Mayavati actually.
Oh, your lordship is reading Mayavati.
So,
I am reading it from the report, my lord, because
it is incorporated in the...
my lord, para 8 to 14 of Mayavati actually summarizes it. But interestingly, my lord, one or two of these paragraphs are not mentioned in Brolia. So therefore, my lord, I read it from the...
Therefore, the trick lies really in the manner in which both you approach it and how you couch the order.
How you couch the order.
If you say that there are contentious issues, we are not fully satisfied, but there is prima facie an agreement, say so, leave it to the arbitrator. Fine.
Good enough. So, my
Doesn't
lord,
matter.
fortunately, my lord, we are not on existence today. Because
we are on
the larger issue.
way out instead of,
We are on not even we are on stamping, my lord, which is one larger area. My lord, we have gone past existence, we have gone past validity, and we have got to admissibility. So, my lord, today we are debating what is to be done. Stamp. So that is in fact, my lord, there can be no dispute. I say this with authority, my lord, that an unstamped agreement exists and is valid in law. My lord, they cannot be disputed that that transaction is a valid.
Repeat yesterday's question, whether under section 35 of the Stamp Act or 34 of the Maharashtra Act,
34 and 33, 35 I have to answer, my lord.
whether it amounts to adducing evidence when an applicant under section 11 produces the agreement, whether it is adducing evidence, whether it is Well, it's in that sense, it's straight away attractive.
Well, whether 33 and 35 are attracted or not. Can I, Lord?
First of all, in section 11 application.
Yes, Your Lordship had asked me that question, Lord. You produced the document. Is
Yes.
that admission into evidence or not? And whether,
That's the only
as a result of that, 33 and 35 engages.
That's the only issue.
Right. Lord, I will go one step behind that and I will say that 33 and 35 is not at all triggered. And I will show, my Lord, how 33 and 35 is not triggered, my Lord. So, my Lord, this is the 246 Law Commission report. I have also set out, my Lord, in the note, the relevant pages of the high-level committee. This is Sri Krishna committee, my Lord. I am not going to read it in the interest of time, my Lord, but that is at page 84 to 87 of this volume. The report starts at page 75. The relevant paras are 73 to 76. My Lord, it is in the note. I am not reading it out. It doesn't advance matter much further.
Yeah.
But it also says that SBP has been overruled. You have to consider the aspect of speed, etc., etc. In fact, now under the new regime of high-level committee, the courts are completely excluded from the appointment process.
Yeah.
There is a complete exclusion of courts from the appointment process. Courts will come in either at 16 or 34 stage to, my Lord, give the final stamp of approval or rejection. So it's not that the courts are excluded. The intervention of the court has been, my Lord, shall we say, deferred, or the application of mine and detailed understanding of the courts has been deferred, my Lord, to a later stage. Because that is, my Lord, how the legislation is structured. That first you go to the arbitrator and decide, and questions of jurisdiction, those 4 headings, my Lord, I'd shown, whether it is subject matter arbitration, etc., all will go there. Now, my Lord, 3 judgments. Your Lordship is looking at Mayavati. May I just show the other 2 judgments before that? My Lord, Duro Felguera. Please see Duro Felguera.
Which volume?
My Lord, volume 2.
It's at page 64.
Duro Felguera
There are page 64.
has been approved in Mayavati specifically. So, my Lord, I just want to show the reasoning. So, Duro Felguera begins at page 64. My Lord, the merits of the matter are really not much of consequence here. I have put it out in the note. There was a supplementary judgment by Justice Joseph, Korean Joseph, of which 4 or 5 paragraphs are important.
Yeah.
Because they have been approved, and that is the approach which has now been accepted. Justice Korean's judgment starts at page 94.
That is the first judgment.
Sorry?
That is the first judgment on 6A.
That's the first judge. That is the first judge. Your Lordship.
6A has been interpreted in number of judgments
Right.
in a different way.
Right.
That is for the guidance.
This is the first one.
First. We are only on the limited issue.
Stamp.
Stamp.
If it is unstamped, insufficiently stamped, what will be the scope
Right.
for the court on the section level?
Right.
Let us confine back to that.
Right. So, my Lord, I am saying that this is the test
On
on other things.
multiplying on a different.
I know. I agree. It's not. It's not.
Otherwise, this is an unending debate.
Unending dispute. Or I will go.
More the discussion, more
More
the
interesting points.
opening the questions to be answered.
Right.
So we confine back to this.
Stamp.
Stamp back.
So, my Lord, I am showing this only in the context of stamp.
Yes.
I am showing, my Lord, 3
But
judgments.
that was not the case in reference to stamp back.
No, my Lord, but the proposition which was approved is the proposition which will apply even for stamp.
52, 53. something.
Yes, my Lord. I'm saying that's the test. Please apply that test. That's what I'm saying, my Lord. It is not on stamp. But, my Lord, it gives the test.
The same problem comes in. Suppose it's just sitting in 482. It's just sitting in a criminal revision. Scope is different. But the parameters when we test is not overlapping. And judge is sitting in 226 and 227. And judge is sitting in 227. Parameters are quite different.
Correct.
But when we, as a judge, when we said
Correct.
almost the same parameters go on overlapping.
Right.
And a lot of confusion goes on. The scope in 226 and 227 and 227.
Correct.
Of course.
So, my lord, I am only showing this. Therefore, I said, my lord, I am not going to the facts of this case.
Para 59 is what you want to do.
My lord, 3 paragraphs.
Para 59.
4 paragraphs, my lord. I've noted the paragraphs, my lord. First, he starts, my lord, after analyzing 47, 48. My lord, 48 is referred to in Justice Nariman's judgment at page 94. That's why I'm mentioning.
59 is what is important.
59 is important. My lord, 56 says that this is the one of the first cases. And my lord, 59
59 is sufficient.
is sufficient.
That's what we
59 is sufficient. So, my lord, I rely only on 59.
Para 59.
59. The scope of power under so and so was considerably wide in view of the decision of the SPP. Position continued till the amendment. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. The legislative policy is essentially to minimize the court's intervention. And intention ought to be respected. This is, my lord, according to me, nothing more seems to be irrelevant. Thereafter, my lord, the next judgment I've referred to, my lord, I've referred to in my note, my lord, is Uttaranchal Pur Sainik, which, my lord, which also deals with this aspect, 2 paragraphs there, and then straight away my note. Uttaranchal Proof Sainik is in page 127. This is, my lord. I believe my Lord Justice Rastogi was also part of it. Page 127. Really, the relevant paragraph is 7. This starts at page 127 of this compilation. It's 2-judge bench. Paragraph 7, my lord, really deals with the issue, because the issue there was whether limitation should be gone into or not. But, my lord, what is important is, I have mentioned the paragraphs. It gives the history of 2015 amendment, etc., etc. And then, my lord, 7.7 Law Commission report, and 7.8 it relies on Duro Felguera, and, my lord, 7.10. In view of the legislative mandate contained in 11.6a, court is now required to only examine existence. All other preliminary or threshold issues are left to be decided by the arbitrator under 16, which enshrines the competence. And then, my lord, 7.11 explains in some detail the competence principle and said it is subject to the court's control. It is not that it is completely the arbitrators like my lord, tilting at windmills can do whatever he wants. There is some court control. And, my lord, 7.12 is also important. The legislative intent is party autonomy and minimal judicial interference. Also at the pre-reference stage is also emphasized on 7.12 and 30. No, this is a little more elaborate. And then your lordship comes to Maya. 115, which your lordship was, my Lord Justice Joseph was already looking at. Lord, this case also was not a stamped case. It arose out of accord and satisfaction. And, my lord, the importance of this case, if I can say, is that it sets out in one place the legislative history. So it can easily be, my lord, paras 8 to 14 set out the legislative history. The finding of the court, my lord, Lord, before your lordships see the finding, please note paragraph 10, the legislative overruling of SBP. Lord, please come to para 10, 125. This being the position, it is clear that the law prior to the 2015 amendment that has been laid down with this court, which would have included going into whether accord or satisfaction takes place, has now been legislatively overruled. This being the position, difficult to agree with the reasoning concerned in the aforesaid judgment. And as section 11.6a is confined to the examination of the existence in italics of an arbitration agreement and is to be understood in the narrow sense as laid down in the judgment in Duro Felguera at 48 to 59. So, my lord, these are 3 general judgments, my lord, on the scope of 11.6a, apart, my lord, from Vidya Drolia, which I will deal with separately. So, my lord, with this aspect, I'm not going to show World Sport Group. My lord, I mentioned World Sport Group. World Sport Group was a case under Section 45. And in World Sport Group, three separate expressions were defined: null and void, inoperative, incapable of being performed. So, my lord, a non-stamped document at the highest may be incapable of being performed. At the highest. Even that, my lord, may not be correct because it's a curable defect. But it is certainly not null and void. My lord, in fact, this phrase null and void, which is used in part 2, is actually only void. Null and void means void. This is in the English text, it is null and void. In the French and Spanish text, my lord, it means void. So if an agreement is void, then perhaps, my lord, it will go to validity. So, my lord, there is narrow existence, then there is validity, and, my lord, then admissibility. So, my lord, we are at stage 3. So, my lord, existence, certainly it exists. I would say that a unstamped document is also valid, i.e. it is not void. So, my lord, so far as 6A is concerned, one word I would like to emphasize, my lord, which is confined. The language of 11.6a, my lord, I understand that after the recommendations of the Law Commission were placed before the government, my lord, there was some rethink and 11.6a was rejigged. And the expression is, first word which is used is confined. And confined, your lordships will note, Lord, we have mentioned some dictionaries, etc. Confined means circumscribed. Confined means, not Lakshman Rekha. Confined means that it is within that limit. So the 11 court will have to confine to the examination of existence and nothing more. So, my lord, this is also part of the legislative policy.
When we come to section 20 of the Contract Act.
20 of the contract. Not voidness.
Voidness.
My lord, none of the section from 20 to 30, which includes contracts which are void, cover an unstamped agreement.
That's right. We are asking you for some other purpose.
Right.
Supposing a contract is alleged to be void as distinct from voidable.
Void ab initio.
Void ab initio.
Void ab initio.
If an agreement is void ab initio, can it exist?
My lord, there is a little gray area there. My lord, two words have been used. One is existence, one is validity. According to me, my lord, it may existence may encompass validity also. So, my lord, it may be argued that existence includes validity, though the legislature has used two different words.
What will be the effect of the contract being declared voidable under the Contract Act? Because
those are the next few sections, my lord. That is an option which is open, my lord. I'll show those sections of the Contract Act.
Would a voidable contract, can it be said that it exists?
It exists, my lord. It certainly exists.
It exists.
It exists. So, my lord, subject to the contract being void, my lord, and therefore, at least in my note, I have, my lord, submitted that formal validity will have to be established to some degree before the 11 court. You will have to, at least as an 11 judge, see whether you know their basic ingredients are.
You got a finding finally.
My lord, then we are back to.
You got a finding.
Then, my lord, we are back to the other question.
That's correct. So ultimately, 11 court. 11
my lord, then
court
we are on the standard. My lord, one is scope, one is standard, my lord.
A sort of nebulous area.
You then.
You say leave it,
But, my lord,
but it should be left open. There's a whole problem arises where
if it's not left open.
if it is not
Left
open.
Yes, absolutely. That's the only way really to reconcile 11 and 16. It will have to be left open. Otherwise, my lord, then whether one likes it or not, a court is a court, my lord. Then an arbitrator will be very chary of however much we say that Article 16 is very wide, give it its full play. No arbitrator will really then want to revisit what a court has done. That's the practical implication. Triple right. Lord, I just, it's not in the compilation. I'll just tender this for the purposes of completion. We mentioned it at page 23. The word confined, what it means. Wait. Second last entry on the right column. To keep within circumscribing limits, to restrict. Just, my lord, it's just an understanding of the meaning. As your lordship said in the other matter, one has to confine to only, my lord, the guidelines. Here I have to confine only, my lord, to Stamp Act.
Once made, we have to remind ourselves that while deciding applications of section 11 is not a court.
It's not a, my lord, full-fledged court of record in the way that your lordships are today.
So this back of the mind goes on all the time. That sometimes creates a lot of problems.
And, my lord, the instinct of the judge is to decide. If the judge sees, my lord, there is a lot of criticism of our courts that we are intervening. Lot of criticism. But, my lord, my personal view, and I want to make this clear, is that the reason that the courts are intervening is because there is serious defect in our legislation in the Arbitration Act. We have eliminated 16 appeal. We have, my lord, not looked at 34 properly, my lord. There are any number of reasons where the courts are intervening because we have not got the proper statute. So it's very easy, my lord, to blame courts because courts will interfere or intervene if there is injustice.
One suggestion which I heard was, when a court deals with section 34, the court should not be burdened with the obligation to furnish reasons.
Permit?
Furnish reasons. Because what is happening is,
That
told that in all these courts, matters are pending for long periods of time where you hear elaborately, something like the SLP jurisdiction.
my lord, it should be a
When you
shorter
say
order.
dismissed, that's it.
But, my lord, if the High Court start passing shorter orders, your lordships will say, and 136 or 37. My lord,
37 itself.
yes, my lord, please see the section 11 orders which are coming to my lords. They are all 30, 40 pages. Because the High Courts have to write such an order to show that I have conducted, quote unquote, an
Application of mind.
intense yet summary estimate of section 11.
And when the party places a
Lord,
document
we are
of
all-
1,000 pages,
We are all responsible.
and then you ask the district judge or the assigned officer, look into those 1,000 pages and report the application of mind. God knows where the application of mind will come
What happened?
in deciphering 1,000 or more pages.
You don't have.
That's the issue.
And then in 37, it's all scope open. If you are not assigning reasons in 34, 37 is open.
My lord,
And the court has no business except to remit the matter back to the district court.
and then, my lord,
Because now it is not possible.
the other problem is we have only ad hoc arbitration. We don't have institutions, and we don't have, my lord, institutions which we respect. So normally in other jurisdiction, if the institution is respectable, then you look at it, and they have also had a look at it. Then you don't really want to interfere. You can, my lord. But today we have so many very peculiar awards also. My lord, one has faced them where you know that there is something that is not.
Like something we look into 136, who is the judge who has passed the order. But that's not the way it was. That is not an advisable situation. You have to look into the merits, not the author. But we look into.
Now, my lord,
This, one more question.
One
I
more.
just wanted to, when we saw it, if just come to section 35.
35.
The question which we troubled you with,
Yes, ma'am.
namely whether its purpose is actually to deal with the aspect of educing evidence.
Right,
There is
ma'am.
another aspect. to it.
Right, ma'am.
This is section 35 once more here.
My lord, could I address your lordships on 33 and 35 now?
There you can.
So that, my
But
lord,
we just wanted you to
Yes,
read this.
35, yes.
Specific issue,
specifically.
because it's important to the question at hand.
Yes.
You just read that.
No instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by any such person or by any public officer, unless such instrument is duly.
So the question is, it actually interdicts to receive, authority to receive evidence nor shall be acted upon.
Correct.
Now, when section 11, under section 11, now,
Are you acting upon it? No?
are you acting upon
Right.
it? At
No,
least.
At least acting on. My lord, this is my lord, my response, and I'll give it now, my lord, because I can understand that 33 and 35 is certainly bothering, my lord. I'll give a response, my lord, not on the larger plane, I'll give a response on the sections. My lord, the section triggers. 35 only triggers if there is a finding that the document is not duly stamped. So, my lord, after the comma, unless such instrument is duly stamped. So, my lord, there has to be first an inquiry as to whether ABC document is duly stamped or not. Or am I making myself clear?
No, the point is, we were actually, stuck up with the concept of admissibility, inadmissibility, flowing from section 35. But we thought that it goes a little further. Section 35.
Or acted upon.
Or acted upon.
Yes, my lord, it goes further. No doubt about it. No doubt. My lord, they are two independent limbs.
So then the next
My
question.
lord, I'm answering the question in a different way.
No, then the next question will be, the theory of unenforceability,
My lord,
which you took exception to.
Yes.
You said an arbitration agreement is very much enforceable.
My lord, I say it exists.
It exists.
It exists.
No, it exists.
It exists.
But can it be enforced if it cannot be acted upon?
My lord, it enforceable.
And when you talk about acted upon,
My lord, enforceable at law.
It should be understood as
My lord,
acted
that
upon
phrase,
in a court of law.
enforceable by law, my lord, is a phrase used in the Contract Act. I'll come back to that, my lord. Please, there's a very interesting, my lord, there is a particular part of Justice Nariman's reasoning which goes on the phrase enforceable at law. So, my lord, I'll come to that. But I have a different answer to 35. I have a very different answer to 35. My lord, 35 will trigger. 35 is a bar. It's a bar, my lord. It's a bar. Subject to exception, my lord. I'm leaving this. It's a bar, my lord. 35 is preceded by 33. 33 is, in a sense, the same side, other side of the coin. So when the document comes, there is a duty on the judicial authority or the arbitrator to look at the document and make an inquiry. The sequitur is that if the arbitrator or the judge or anybody finds that it is not duly stamped, he can't even act upon it. So, these are two parts of the same legislation. So, my lord, the bar comes because, my lord, so 35 is the bar and 33, my lord, your lordship, go back to 33.
Let us put it slightly differently. When a person, without taking care to get it impounded, without paying up the duty with the penalty, he rushes to an 11th port. He rushes to 11th port with an unstamped or inception.
Unstamped. No, let us do unstamped. Unstamped.
And no doubt about that it is a document, is an instrument.
My lord, that's where the doubt is, my lord. Your lordship says no doubt about it. That is where, my lord, I have.
No, you have yourself said.
My lord, I'm answering myself, my lord. Your lordship.
Because I see yesterday you say an agreement to refer, even if it is a separate independent agreement, has to be stamped. So we begin with an unstamped agreement.
My lord, I'll go one step.
What you're saying is something different.
The
simple question is, can you
act upon?
My
lord, I'll answer.
Will not the court be said to be acting upon?
Right. I'll answer. My lord,
forget about evidence.
Forget about it. Forget about it.
Very act of referring to the
My lord, I have an answer on acting upon it. I'll come to that. But, my lord, I have a preliminary point, which is that, please see 33.2. Please see 33.1, 33.2, and then 35. And I'll explain, my lord, why 35 bar is not even reached. No, 35 bar has to be reached. 33(1) says, every person having by law consent of parties authority to receive evidence, every person in charge of public. Now, this is the same language as 35. Except an officer of the police before whom any instrument chargeable in his opinion, which duty is produced or comes to the performance of one, shall. Now, my lord, these are the critical words. If it appears to him that such instrument is not duly stamped. Now, my lord, the examination by the person is to examine whether such instrument is duly stamped or not. That examination is found in, my lord, 2. For that purpose, every such person shall examine every instrument so chargeable and so produced before him in order to do what? In order to ascertain whether it is stamped with a stamp of the value and description required by the law in force in India when such instrument was executed or first executed. So, my lord, if 33(2) is triggered, then 33 will follow. And if, my lord, if I have to conduct this examination, then I will come to a conclusion that it is not duly stamped. And then if it is not duly stamped, it will be barred. So, my lord, the steps are different. We have jumped 3 steps. So, my lord, my submission is that 33(2) examination is not to be done in 11.6. That's the submission. So, if 33(2) examination is not to be done in 11.6, my lord, neither will 33 apply, nor will 35 apply. 33(2) examination is to be done, yes, by the arbitrator. So, my lord, it is not that this is being escaped, but this examination, if you are not required, but therefore I come back to scope of authority. It is not within the Lakshman Rekha or scope of authority to undertake this examination. Because, my lord, if your lordships do undertake this examination, I have confidently today told your lordship, it is arbitration agreement is to be stamped. Till yesterday, my lord, there was a 3-judge bench judgment of this honorable court which said arbitration agreement has not to be stamped. Today, there is a controversy inter parties on what is the value of the stamping, what is the person to be paid, what is the dispute. So, my lord, if 35(2) is to be done by by the 11 court, the bar in 35 will hit me. But 35 bar will not be triggered because 35 will not apply. That's the submission.
Can you not harmoniously interpret 11.6a with section 35 as we are duty bound to do? Both are central enactments.
My lord, 35
No,
was...
are we either we close our eyes completely to 35?
Your lordship is not closing eyes to 35 completely.
We are not.
No, you are only deferring it.
No.
You are not, my lords are not closing eyes to 35.
The point is that we are bidden to not act upon the document
Unless it is duly stamped.
unless it is duly stamped.
But how-
It is stamped to begin with.
No, my lord.
Duly
It says
stamped is okay.
it is
In a
duly
case-
stamped.
In a case where there is no dispute that the document has to be stamped, number one, we are taking that case alone.
My lord, then we are now going beyond the existence of the agreement.
No, that we are telling you. See, when 11.6a was enacted,
Right.
it was enacted with a particular purpose. What was the legislative history, judicial history, SBP, 7 judges, earlier
My lord,
judges?
the
They
purpose...
were going into 3 categories of cases. They thought that all of this is covered under section 11.
Right, my lord.
So actually they trimmed the jurisdiction, as it were, and said you have to only look into the existence of an agreement.
Now, my lord, by looking into the
Now,
existence
existence
my lord.
existence of an agreement,
Right, my lord.
which we have to also bear in mind on in the same breath, we have to also say that we have to act upon it.
My lord, your lordships are assuming that bar is there of acting upon.
That's right.
I am saying that bar, my lord, it is like you have not even reached the point. My lord, this 35 will trigger only, my lord, because this expression duly stamped, my lord, has been explained in 214. It is not stamped, unstamped, my lord, it is duly stamped. So, my lord, if it is duly stamped, then there is no bar. It may be in cases, my lord, a document may not require to be stamped at all. I have given an example. So, my lord, the question is, will this court, or not this court, my lord, the 11th court, be required to make that inquiry? Yes, if your lordships feel it is required to make the inquiry, what are the consequences which follow? That is certainly one view, my lord. But having used the word existence, having, my lord, curtailed it from admissibility, validity, existence, my lord, confined. It is confined, my lord. It is a list which has to be ticked off. Is there a valid agreement? My lord, if it is not then the word, meaning of the word, my lord, confined will go.
See, the validity of the agreement, no difficulty.
So, my lord,
You have to not confuse an unstamped agreement with an invalid agreement. It is not. You are right.
right, my lord.
In
So
that
moment
sense,
it is
not,
valid.
It is not an invalid agreement. It is.
It's a valid agreement, no?
It takes a valid agreement.
It's a valid agreement.
No, what you're saying, it is a valid agreement.
It's a valid agreement.
It exists.
It exists.
It exists. It's
Right.
not as if it is void.
It's not void.
Both of that, you're
So far, so good.
The question is, when the courts were in section 35, which is equally the mandate of Parliament,
My lord, 30,
says that don't act upon it
unless stamped.
unless it is stamped.
My lord, but unless it is stamped is an issue which has to be decided.
In a case where,
My lord,
in a case where
that's a
nobody has
presumption, my lord.
in a case which we are giving us, that all these, because the three judges bench which is referred, it is wrong in saying that an arbitration
So, my
agreement,
lord, that's the issue, my lord.
if it is completely unstamped,
My lord, that
there
is
is no
the issue.
dispute about it.
That is, my lord, that is the issue, my lord. The question is, your lordships are therefore assuming that 35 is complied. I am saying you have to look at 35 and you will have to look at 33. I am coming to acted upon, my lord. On the phrase acted upon, my lord, how that works. I'll come to that, my lord. My lord, also your lordships will have to keep in mind, my lord, Stamp Act is 1899 when we had an 1899 Act. My lord, we have progressed considerably with the arbitration. There have been 1899 Arbitration Act was there. Lordships will have to give some interpretation which will make both workable.
Exactly.
Right? Now, my lord, I am suggesting that the only way or the practical way to make both workable is to leave this decision of stamping good, bad, indifferent, high, low, whatever it is, to the arbitral tribunal. Who has the power? There is no dispute he has the power. The sections say so. And he has to obey the law. So, my lord, the other view is, let's test the other view, my lord. The other view will necessarily mean that the legislative, my lord, intention of appointing an arbitrator merely on the existence of an agreement, whether prima facie final or whatever it is, and limiting the scope of the authority will go for a toss. Now, that's the reality. That is what had weighed, my lord, with the full bench and my lord, and it is not our say so, it is the legislative history and the reason for bringing the amendment through. Today, my lord, who is raising this question? Let's put it a different way. Who is raising the question of non-stamping? The person who does not want to go to arbitration. It may be that he has to pay the stamp, but he doesn't want to go to arbitration. So, my lord, or take a my lord, case where you want, which we are not concerned with, the interim release, section 9. We are not concerned in this case. Who is raising the non-stamping defense, my lord? And how do we balance it? Do we, my lord, put a chokehold at the stage of 11.6 when 33 and 35 can be equally, my lord, read? My lord, I ask myself a simple question. Is the 11.6 judge required to do 33.2? Is he required to do this or not? If he is required to do this, my lord, this will go against 11.6. If he is not required to do 33.2, then 35 will not even come into the picture.
So according to you, the conundrum is only this. Who is to decide?
That's all, my lord.
Who is to decide? And according to you, the section 33(2) of Stamp Act, that examination need be done only at the stage of first 16 by the arbitrator.
Not at the stage of 16, my lord. Right at the beginning. It doesn't even have to go to 16. He has to do it on virtually.
By the arbitrator only.
Yes, on day one. Because, my lord, moment you have an unstamped agreement, none of the substantive rights can really
In
be
short, 33-2,
33.
that need be looked into or examined only by the arbitrator.
And that will work well, my lord. It will work in every way. It will work. The revenue will be protected. The document will be impounded. The decision will be there, subject to court control. There will be no delay. Why should, my lord, I put it in a different way. Why should the court burden itself with this headache? Unless your lordships interpret as this is a gun to the head, you have to do it. So, my lord, that's the question. Why should the court burden itself?
Do it completely, complete circle. For the extent your contention.
Right.
And we also had prima facie what to say is workable. And it's a speedy
Right.
disposal of the applications and let the parties come to arbitration. Ultimately, what will happen? From our 11th jurisdiction, it will transfer to the jurisdiction of the arbitrator.
Yes.
Now, obviously, in the written statement, come forward, the first objection would be unstamped or
Yes. Yes.
insufficiently stamped.
That will be fought out.
Now they will say you can't proceed. First get an inquiry of 33 to
No difficulty.
and then 35
No
and
problem.
thereafter, meaning thereby, then what we are going to hold and record a finding will be stuck by the arbitrator and then he will take another.
No, your lordship will not record a
I-
finding.
No.
Your lordship will not record
I'm
it.
not saying. Suppose if we take an inquiry
Yes,
and
ma'am.
record a finding
Right.
in reference 33 to or whatever it is and say, no, sorry, whatever the document is, it's fully stamped, nothing doing. That chapter is over, let the parties address on merits before the arbitrator. There's one theory.
One theory.
The second theory, as you say, is sorry, you don't intervene in section 11 jurisdiction. Leave it to the arbitrator to examine. All right. We agree. Now, the first question would obviously the person who doesn't want to go for arbitration
We'll raise it.
will raise it
My
definitely.
lord,
raise it.
three things will
He's
happen.
a sane man. So,
Aren't we coming to the same conclusion? Is what your lordship is saying.
we are on different point. So, when the matter is now instituted before the arbitrator and the person who is not inclined to go for arbitration,
We'll raise the point.
definitely raise it.
Definitely raise it.
Obviously. Now, the arbitrator will also extend the exercise. Yes,
He will have to undertake the exercise.
To 33.
Yes, my lord.
You do inquiry and then 35 as to what should be adequate
Penalty.
stamp or whatever it is.
Penalty, stamp,
Now,
whatever.
now, the legislature also says simultaneously that the arbitrator should also conclude
Right, my lord.
within 1 year plus 6 months from the service and all.
No difficulty.
Now you will find in the system which we are today privileged, the arbitrator will be stuck to proceed unless that document in reference to which the arbitration proceedings are to commence is not being properly and adequately, insufficiently or sufficiently
Lord,
stamped.
I am doing some arbitrations like that. I'll explain, my lord, what happened.
So
I've seen that.
what comes to us, subject to what? Are we not to step in or leave it to the arbitrator to
My
make a call
lord,
and
let's
do it in his own way?
let's play this out.
Or
Should your lordship not decide it?
not decided, right?
So, my lord, let's play this out. Supposing this very point of unstamped is raised before my lords, right? My lord, in practical terms, this, my lord, one is the interpretation of 3335. In practical terms, what has happened, my lord, and I can vouch for this, Delhi is taking a different view. In Bombay, virtually everybody is raising this as the defense. So you file a reply, then you file a rejoinder, then you hear the matter after a year. No, this is the practical reality.
That's correct.
This is one version. my lord. So the arbitration is stuck. You've not got an arbitrator yet. The other, my lord, option which I am suggesting,
Yes, let me begin with a caveat. The present proceedings fall within a very narrow compass.
Correct,
Yes,
correct.
already there is a direction and everything has been laid down. Whatever the practical difficulties, this one vacuum is to fill up.
Narrow
Only
is-
to, yes,
That is a narrow.
That's-
no
that's all
question of any
because-
further hearing.
yes,
on that.
yes,
We will simply, make it a little bit more workable.
correct.
We can't be, reviewing it. That's
Yes,
not
exactly,
possible.
exactly.
Now, my lord,
What are your suggestions? Just
Yes.
tell us.
my lord, what I've done is, as per your lordship's direction, I've taken para 198 and I made a chart. And where is unworkable, we have put it in red. What is the, so there are two
So
things.
that what is the provision to be substituted, that's all.
Yes, yes. So the changes
There's
are.
no need for any discussion, order and all that. We can,
So what we have done last
we'll
time.
dictate the matter in court, open court. There is nothing to be reserved or anything.
Yes, yes.
We can't, there is nothing to be, can't be reopening the whole.
No, no, no problem. At least make it workable, that's all.
So,
And only one thing in the judgment earlier, apart from the majority judgment, there are concurring views of this Chandrachud and Justice CP. And 2-3 passages where the court has taken the trouble of defining what's a terminal condition, because they are concurring views. That will also be the views of the court. So if Lordship can see that also after I finish this. Now,
We can't take.
we can't be interfering always.
one 198.1, but this is a chart in landscape where the second column contains what is the original guideline as per this earlier Supreme Court judgment. Now, in reading, I have put what act to make it more workable. But this is a landscape, or this is Rastogi, we see this, it's in landscape format.
Why this one?
No, there are two things. What we have done is, I'll explain you. One is suggested modifications which are in track, which is in a vertical format. Lordship will just see this one and the same block. And has the Lordship got the landscape format? Horizontal format?
It's a guarantee.
Yes, yes. That is the final thing. I have it in 3 stages. One is the suggested changes post directive. Then one is in track, I have given what are the portions to be cut out. And here, my lord, I have given the suggested modifications. May I read it? Only the reading portion not supposed to see.
Dr. Banerjee and Banerjee can. How long? Because we don't want to keep Gaurav Banerjee and
Definitely take 30 minutes.
30 minutes.
Yeah, so I think
So your matter will come tomorrow. That's all. We don't want to keep you waiting. The rest of the matters will come.
since the Lordship is going to dictate also.
We'll try to.
Yes.
Close it. Otherwise, we'll dictate tomorrow. There's no keeping you, no question of reserving it.
No.
Are we discharging Mr. Banerjee even if he's interested to listen to Mr. Datta?
I'm so sorry. Never stand.
Always a privilege to listen to Mr. Datta.
But I'm also discussing that arbitration point with him. So very interesting.
Mr. Banerjee, how much time you are supposed to take now? Mr. Banerjee,
My lord,
how much time you are
I
taking?
have 3 judgments left, the 3 reference judgments.
So that tomorrow we can
And,
conclude.
yes, my lord, and I will also address 2 questions of your lordships. One on the 1940 Act, what was the position? And second, my lord, that 33, 35, etc. That's all there is.
Half an hour maybe, like we can just time management so that,
My lord, those 3 judgments may take longer, my lord. I in all honesty, my lord, your lordship,
Whatever
may,
they-
I've taken only 2 sessions, my lord, up to now.
Oh, take it.
No, we don't.
Keep your-
Yes. So, my lord, so Lordship will see whatever is suggested. If a Lordship approves it, then that will be modified. If Lordship doesn't approve it, it goes.
That's right.
Yes.
Simple.
Now, Lordship will kindly see.
Yes.
We have, as far as the first is concerned,
Yeah.
it shall be in writing clearly stating. May I read the second column with the modification so that will be easy, my lord, what has been added.
This is 1.4, is it?
Lord, 198.1.4 are the conclusions,
All
the
right.
guidelines. Lordship directed me yesterday that.
You're right, you're
Yeah,
right.
just make the changes and suggest it because we are not in review, it's not a larger bench.
Absolutely, absolutely. It shall be in writing clearly stated.
Please read the suggested modification. We'll go to that. So reading 2 columns in reading. Or may carry a greater possibility of harm than reasonable benefit and may thereby cause him pain anguish. Why that is necessary is because the Indian Council of Medical Research published the definition of term so and so. This defines potentially inappropriate treatment or intervention aimed at cure carrying far greater possibilities of harm I give lots of an example. You know, there's an elderly lady, I'm giving true life example for you. Elderly lady of 1993. She's perfectly in good health. She's carrying on a normal functions, barring slow motion, movement is slow, etc. She has a cerebral stroke. Yeah, she's admitted to hospital. Now, technically, the clot can be removed by a brain surgery, but you'll have to open the cranium and operate open brain surgery. The doctors advise that, look, at her age, it is not advisable to have such invasive surgery where you're going to break open, cut open the brain and do it. The possibility of her sustaining that surgery, she may get surgical shock, she will not survive, or even if survive, you don't know what will be the further complication. So that is the case where she's not terminally ill, she's not in a vegetative state.
So she is conscious.
No, she's not conscious.
Okay.
After cerebral stroke, yeah, I mean the exact example of that I'm personally known to the doctor.
That's right.
So, and this has happened in so many families, Manoj.
So that's why we are telling you, if she is conscious, she is able to take a decision independently.
Yes.
You don't need this.
You don't need this.
That's what I'm-
No, so what I'm saying is,
the important thing.
Correct.
She should have.
Lordship rightly pointed out, all these are cases where the person has reached a stage where she cannot take this thing. And that's why Justice Chandrachud puts the thing of what is called the subjective standard test. That is to say, when the man was conscious, he said that in circumstances A, B, C, D, please don't put me to this. Now he's in a coma. Now he's in a position where he can't decide. So the court says, respecting, because privacy includes personal autonomy, respecting the autonomy of the individual. When he was in conscious state, he chose that I don't want this. So when he's not in a conscious state, please respect his wishes and follow the advance directive. Therefore, I just wanted to add this, that there could be a situation where what the ICMR calls futility of treatment. The treatment is technically possible, but may not be worth treating like an elderly patient. And this has happened in more than one case. Another case I know, the person had a stroke. They said instead of opening the brain, you have to cut open this vein and put some stents here. Again, the person was 92 years old. Then the doctors at Madras said, look, it technically is possible, but we won't advise it because the patient may not take the strain of the surgery and it may not, we don't know what benefit it will get after this. Quality of life may not be there after
So
that.
who would do it then?
No, I'm saying,
If the patient is unconscious.
so these patients would have made an advance directive.
No, who would have done that?
What?
This particular treatment, at whose instance would it be done?
The relatives, the children?
So what would they be doing that for?
No, the point is this.
They're just telling you.
Yes, they will be relieved of the burden of taking a call. Some people will say, let us take the chance. Why? Suppose the person is 75 years old.
Are we then proceeding on so many presumptions?
That's why the
There will
general
be somebody who is not, will have to take a decision, he'll be put in a dilemma, and therefore it is put an
Yes, that's the whole logic of advance directive. That the point is the person makes a choice when he's conscious. That's the logical judgment of the concurring judgments of this. They go into all this more elaborately. It is discussed the thing. So what we are saying is we don't want to restrict it to terminally ill, PBS, and this. So we just put it generally, if your lordship approves, or may carry a greater possibility of harm than reasonable possibility of benefit, and may thereby cause him pain, anguish, suffering, and further putting. So all that we're adding is may carry a greater possibility of harm than reasonable possibility of benefit. So it's a weighing this.
And in fact, in this, we will tell you.
Yes.
Some of the amendments to the Income Tax Act, which have brought in its string greater complexity, engendered more litigation. We perhaps think, with all due respect to you, that these words.
No, I'm not complaining, Guru.
Yes.
I'm not complaining.
all due respect to that, or may carry greater possibility of harm than reasonable policy. This itself will become a matter of long debate.
No. This, your lordship, the last column, this is not my phrase. The Indian Council of Medical Research, on the basis of consensus received,
That is the guideline kind of.
now accepted by the medical fraternity. This is not a suggestion by me.
Is this the problem which is brought you to this court? The fact that this is actually being kind of a spoke in the wheel kind of situation.
No. We are envisaging what are the end of life situations.
That's right. I'm saying
Yes.
why you came with an MA is some reason.
Yes.
Is this the reason?
Yes.
Because otherwise we are creating a new second.
No.
What we thought was, will it not work with the existing guideline? As far as possible, let us not.
No. I agree. This will.
So let us read that existing guideline once more.
Yes.
Shall be in writing clearly stating as to when medical treatment may be withdrawn or no specific medical treatment shall be given, which will only have which means what are the medical treatments withdrawn and the treatment which will only have the effect of delaying the process of death that may otherwise cause him or her pain, anguish, suffering.
Yeah.
It covers.
That covers everything virtually.
No, Mr. Datar, the red line part.
Yes.
Are we clear in our understanding
Yes.
that since it is coming from the research done by the ICMR and inputs put in, a medical professional will be in a position to understand what it means?
Yes. And this is
Is
where
that what
medical
you're trying to
treatment,
say?
Your Lordship, absolutely right. This italicized red line portion should be read medical treatment. What is the medical treatment? If the medical treatment is going to have a greater possibility of harm, then reasonable possibility of benefit, all in the realm of probabilities. This 90-year-old patient may very well survive.
That's
brain
right.
surgery.
So can we say that all the medical treatment, once again use the word medical treatment there,
yes.
instead of,
or the medical treatment may carry.
I mean, so that you put
I'm
a
saying
little
no,
clarity.
nothing is lost. It makes it more workable. That's my humble submission. I agree, Your Lordship.
So therefore, the medical fraternity must understand that
Yes.
this is what it means.
Yes, that's why the last column. Yes, Lordship.
It should not be innovation of the court or Mr. Datar or Mr. Natarajan.
But I will just clarify a
particular thing
I
which is-
suggested. Nothing is from our own suggestion. We have discussed with doctors and there is a complete report of the ICMR which is introduced.
It's capable, this is capable of getting misused. I think it's much wider the expression is given. May not be scope of review, may not be scope of these particular proceedings. Already everything has been laid down. You have to see only the practical difficulties.
We spoke to doctors in the evening. They said, please add this from ICMR. You don't want to add it, leave it. I'm not a big quarrel. I'm saying it makes it much easier because there's a medical treatment which has every treatment as a benefit, as a possible harm. So the doctors take a call that in a 92-year-old lady who's had a stroke, who's otherwise not terminal, is completely normal, but now she's not conscious. The possibility of benefit is much less than the possibility of harm causing to her. That's what I'm suggesting. So I don't think anything wrong in including it.
And, like a tenant landlord comparative hardship theory.
No.
Yeah.
But it's not a big issue, my Lordship. I personally feel nothing is lost by adding it. I leave it to your Lordship.
What is your view?
That's it will open up everything. I don't think it is not in a matter in which the application for this one, the correction or practical difficulties are brought.
What is
It can be examined.
I don't think it's necessary.
Let me say it out aloud, respond to my brother judge. Suppose the element of misuse is left out of our consideration, then this is a harmless thing otherwise, in my, as I look at it. But when we examine it in the context of a possible misuse, then maybe something else will come in.
That's why I got a primary board. Misuse is taken up by the primary board. Who takes the call? Who takes the call?
See, you should protect the doctor against the potential litigation
That's why I'm saying.
by the, say, next of kin of the.
Lord, that is exactly the reason why, my Lord, I'm grateful.
One other aspect, a clarification cannot lead to
Review.
more confusion.
My Lord, we are trying to solve the problem, my Lord. If we are going to say that we can't add a word or sentence, then it's a different issue altogether. We have met doctors, why we have taken so much of trouble and spent so many hours is that doctors are finding it practically. Please think of the medical, I'm humbly requesting, think of the medical fraternity and think of the patients. Lord, my own friend has gone to Bombay, the magistrate says come at 3 o'clock, come at 4 o'clock, I'm not ready today, I don't have a, that's why I'm saying.
That's a different
Yeah.
matter altogether.
So I'm just suggesting, why I'm
All
suggesting.
right, we will just, I will consider.
Yes, I'm just saying, my point is,
We have taken note of it.
I-
Next point.
Lord, may I just say something? If it is altering the structure of the earlier thing, then don't accept it. If it is only clarifying or helping,
We understand that. Next one.
next.
I
It may clearly indicate the decision rate circumstances. Your Lordship pointed out that this is not very clear. So we just added this for your personal Lordship's suggestion. It should clearly indicate that life-sustaining treatment may be withheld or withdrawn if the treating team of the executor determines that it is potentially inappropriate at a time when the executor becomes a patient and loses decision-making capacity in relation to administration of treatment.
Be kept.
This can be.
Very good. Next, Lord.
We will be very clear then.
Yes. Now, Lord, this para 198, in fact, this is very important. 198, this is Ravikmal also mentioned, that is the most, that recording is very important. The document should be signed by the executor in the presence of two attesting witnesses, preferably independent, and countersigned by the judicial magistrate. We have put attested before a notary as defined in section 2D of the Notaries Act, read with section 11 of the Act. But this suggestion was made in the earlier judgment also, but they didn't incorporate that notary. I thought notary is good enough because
Are you very comfortable with the notarial process?
at least it attested before somebody, madam. Attested before somebody.
Instruction from the government, and so far as this clause is concerned, it can go before any gazetted officer. That would be more.
That's what we said. Whether gazetted officer means there are a number of gazetted officers.
Notified gazetted officer, that can be done.
No, that's what we're saying. There are a number of.
Any notified?
Any
But
notified.
I remember when gazette is a nightmare going because officer will, we must know some class 1 officer, go to him, they come in the night. The notary is the best, but in most courts, the notary is sitting.
Stroke and gazetted officer.
Yes.
That can be.
Yes, because what happens in most courts, notary publics as there, sitting there. You can go there and get it done.
Stroke would be.
Actually, they'll get some. Personal.
I didn't think of that. No, there'll be some sanctity, but it has been signed before a notary public.
What do you say to this?
You have lost the sanctity.
Notary or gazetted officer, that would be better. That's what the. Because,
Let it be in the alternative.
yes, that's right. That's right.
You have lost the sanctity of notary now.
Yes.
Notary can come to your residence and put the stamp without the paper being signed.
No, but there are many people who, though there are notaries also. As in everywhere, there is like medical certificate also. Some doctors will give, some doctors will not give.
You have lost the whole sanctity.
So this we make it, subject to what we have.
Flash.
Notary stroke
Or
Notified gazetted officer.
gazetted officer.
notified gazetted.
Because in government itself has eliminated gazetted officer in many things.
Yes.
Today, yes.
No, from
Everything.
everywhere.
I remember earlier you have to
Yes,
go and
yes,
contact
yes.
some IS officer. If they come in the evening, go and get it signed.
As a lawyer, every second man will come to you, take my documents to some vessel officer and get it.
In addition to this.
Good, the government has
Eliminated gazetted officer.
not required.
In addition to judicial magistrate.
Gazetted officer.
It makes it more workable. We are trying to look at.
Right. We make it workable because suppose the person is not able to move. Suppose the person is wheelchair bound, mentally conscious. Now, for her to go to the notary public may be a problem. Mr. Natarajan may be right. At least we can request the gazette officer. If he's a known person, he can at least come home and.
You have used the word to attesting witnesses.
Yes.
The attestation has a particular meaning.
Two witnesses.
No, witnesses is not mere witnesses.
Yes.
Attesting witnesses, it has been defined, as you know.
Yes, yes.
The Evidence Act.
Yes.
The Transfer Property Act Evidence Act.
Yes.
There's a difference between an ordinary witness and an attesting witness. You know that.
Yes. 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 The person attests to the signature.
Animus
Yes.
should be there.
Yes.
And then you should see it, etc. Okay, that is already there.
It's already there. And why the Lordship is right. Suppose both the Lordship said, what about the misuse? At least if a matter goes to court, they can say, I was the attesting witness. I saw the person signing.
That's right.
Next person.
So this is a notary under or a gazetted officer.
Yes.
In addition to here.
So the poor
Yes,
man.
no, Lordship, please, my humble prayer is no JFMC. Folded hands and requesting, don't put JFMC. That is the biggest hurdle for this thing to work. Say forward to JFMC in Bangalore.
In fact, it will be troubling the magistrate also. We'll be having so many.
Lord, I'm sorry. I got a WhatsApp received from a lawyer in Bangalore about this going to JFMC. Now they say, is he going to attest on the judicial side or the administrative side? I got a whole message. What the Bangalore court says, you file a criminal petition. Then the section is saying you're filing a petition, where's the pending matter? And is it an application? Then what happens, I'm told now with all the digital thing, once you make a criminal application, you know, the petition on the criminal matter, it is picked up. So when you go for passport or anything, there's a record that you have applied to the criminal court for some clarification. I got a WhatsApp message from a lawyer in Bangalore. He sent me at night. So let's leave the JFMC, madam, my humble request.
My brother is concerned about review, modification, whether we are exceeding jurisdiction. That is what.
No, but see, Lord, the point is, suppose the Lordship records that this particular passage is creating problems. Nothing wrong in modifying it. My humble submission, Lord, we modify matters so often. Rate of interest is modified. This is modified.
So from the word and countersign, that will be replaced by what you have given,
Yes.
isn't it?
Yes.
Then what else is there?
Sorry, Lord, and one more thing in JM Farsi, the magistrate says, unless I get a direction from my chief justice that you are entitled to do so, this is not part of my job. That's another problem they face.
That
Because-
can be sorted out by.
No, I'm saying why you just, if you can avoid
It
it.
may not be because he is designated for that purpose by the district judge, going by the.
Well, I'll leave it a lot, Lord. That's my biggest request, Lord.
But of course, this practical difficulty that is there. The other question is not because designated by the district judge. For what purpose? For this purpose.
That's what I
So the other question may not have.
Then he says you must file an application,
That,
a criminal petition.
the other question may not.
I'll let you. No, then once this magistrate goes, not the other paragraphs go. And just for your lordship's consideration, I've given a separate
Which paragraph goes?
paras 198, 3.3.3, 3.4, they go. Because all are JFMC.
No. So in place of JFMC, the notary public stroke gazetted officer will come.
No, that's coming in 198.3.2.
That's right. We're talking about that.
Yes. No, I'm now come to 198.3.3.
No, we are concerned about and the notary. Okay, you have put notary, we are putting gazetted officer also.
Yes, your lordship is right. That will automatically fall.
He says as a consequence of that, 198.3.3 and
Let us
3.4
be
go.
notary and gazetted.
Yes, that's, as a consequence of that,
Notary or
3.3 and
gazetted officer.
3.4 will go. That's what he says.
This can be done.
Yes.
Lordship is like notary or gazetted as the case may be.
That's right. As the case maybe, that's enough. Anything else?
Then please come to 198.3.5. The JMC shall cause to inform the immediate family members.
Mr. Tatar,
Yes.
point 3, digital format, keeping in digital format, can't be shipped to something else. Why to delete it?
Yeah, sorry, my friend has got it.
So then
Yes.
again, we have deleted, you're deleting everything, huh?
Yeah, no, one in 198.3.6. Lord, please come to 198.3.6. I'm answering that point in 198.3.6. I'll just finish this one. I'll just come. Just
right.
Just bear with me for a minute. Just please bear with me. I'll finish this. The executor shall inform and hand over a copy of the advance directive to the surrogate decision makers named in the directive, as well as to the family physician, if any. So instead of putting immediate family members, we put surrogate decision maker, which is a term used by the concurring judgment of the.
Family physician has disappeared.
It is there, as well as family physician.
It's there,
Yes.
but in real terms, it's
Today, very difficult to get a general physician. Very difficult. Everybody is a specialist. If any.
You have said the witnesses and the jurisdiction JFMC, I'm reading 98.3.2.
Okay.
Shall record their satisfaction that the document has been executed voluntarily, etc., etc. Now, where do they record it actually?
In the same document itself. In the same advance directive, they will record it.
This document, because it doesn't require to be stamped and all that. We proceed on the basis.
Yes.
It doesn't have to be stamped, number one. So it'll be on one white sheet of paper we take it. It'll be typed or written or whatever. So overleave or on wherever there is.
At the end of the document, there'll be attesting witness 1, attesting witness 2, and there'll be notary public. So they will say, or the gazetted officer, they will say that this advance directive has been signed in our presence, and the person and Mr. So-and-so
Full
was
understanding.
full understanding. Because that's the Supreme Court language, we could not.
So we can't change that. Let it remain. So that let it remain. So 198 3.2 will remain.
Where is this?
3.2 will remain. Let us keep it like that. That is not complicated.
But just let's see this format.
No, let's not see. It's
Well,
there.
Lordship mentioned we have got 5 copies. So since that's the attestation is important.
Then the next is 98.3.3.
Yes.
You have said the JFMC shall preserve one copy of the document in his office that you are going to delete it.
No, I'm going to make a change in 198.3.6. What this is, Rastogi asked about digital format. We have got one suggestion.
No, what you're saying is what is to happen to 198.3.2.
This has to be deleted because the JMC is not there.
There what you're suggesting is that because it will be now done before the notary or the gazetted officer. Now, if it is done by the notary, let him keep a copy at least in his office because he'll have an additional copy. Okay.
Please see 198.3.6, then we'll come to it.
Because otherwise, what will happen? Who will where?
No, like a will, not who keeps a copy of the will.
At least a copy should be there, so it can be counter checked.
Digital format.
Six.
A copy shall be handed over to the competent officer of the local
No,
government.
second one, the executor may choose.
As choose to incorporate one in their existing electronic health records, if any. Isn't mental.
So there's 198, we will say,
I'm told that there's a national, please inform the court. She's done a lot of work on this.
No, Your Lordships, there is the National Digital Health Mission under which there is, an initiative are being undertaken to ensure that all hospitals have interoperable electronic health records. So if I go to a hospital and I sign in voluntarily with my unique health ID, that hospital will have access to all my patient records, all my past histories, including from other hospitals, and this will be available to another hospital should I transfer there at some point. So what we've suggested is that the most important thing is for this directive to be available to doctors. So once it has been executed, the executor may choose to incorporate it and integrate it with their patient records so that this then automatically becomes part of the patient records and shows up when you take admission to hospital.
wherever, whichever
Exactly.
hospital he may be,
Exactly. And this is voluntary. So there's no compulsion.
no
on
right
the
to
executor
privacy.
to do this. And the NDHM has now privacy standards for all electronic.
So where have you
records.
incorporated that?
So this is under 198.3.6 is what we've suggested.
Is that a government initiative, this particular portal,
Yes, yes.
integrating all the medical records? It's a government initiative.
It's a government initiative. And there are published standards on privacy.
Privacy, etc.
Or she may say records, if any, as mandated by the National Digital Health Mission.
So let me read that time, 198.3.6, is it?
Yes,
You have added there?
yes. The next page, page 4.
So we have not completed about this 198.3.5.
No, What happened was, my Lord Justice Rastogi asked, who will record it, any digital data? So I said the digital data part is coming in 198.3.6. That's why we jumped to
What
198.
about 198?
We can go back. We can go back.
No, it is there, 198.3.5.
Yes. So there, and hand over a copy of to the surrogate decision maker named in the directive, as well as to the family physician, if any. Then the next paragraph is on digital.
What is this? What is it? Shall inform and advance?
No, because the Supreme Court said that the magistrate should inform the immediate family members so that information that so-and-so has signed.
So the executor in place of
Yes.
the FMC.
Yes. So it's not that, at least the family members know that Mr. X has made the advance directive.
Correct. So that will be, now you are replacing it.
Yes, no, what I'm saying is, instead of putting immediate family members of the executor, I have put advance to the surrogate decision maker named in the directive, as well as to the family physician. Because advance directive will say, advance requires there should be a surrogate decision maker, like an executor in a will. So I must tell the executor, suppose.
What do we die? No, if you say this, if you put it, confine it, that man die, becomes incapable of acting otherwise. He becomes himself a paralytic.
He gives number and not to you.
There
Why do you
will be
create-
multiple surrogates.
Huh?
You can list multiple surrogates.
But when you do a will, we put a person who's younger also in. on the-
Why don't you put family members? I mean, normally, when there's a
Tell me.
post-death donation of body,
Yes,
the
absolutely.
family members only inform.
This is because this is the court's own requirement on what an advanced medical directive must.
No,
contain.
the court's a family member. Why do you make it surrogate?
No, Your Lordships in.
198.5 immediate family members.
There is it in the previous paragraph.
This we should think well. No, see 198.3.5, it says JFMC shall immediately inform the immediate family members
You're
of
right.
the executor.
If I may just take you to 198.2.5.
We're talking about 198.3.5.
No,
What
there's
my
a
friend is
point I'm making, Your Lordships, that the court has.
We will not get too much.
No.
We are, I think.
No. What I'm saying is we have only reproduced the paragraph which are going to be changed. 198.2 is not being changed. At page 130 of the judgment, your lordship takes the book.
We have reason to hear 198.3.5.
No, what my friend is saying is the surrogate decision maker comes from your lordship judgment in 198.2. And lordship said only point out the changes, don't touch other things. So we only highlighted it. Your lordship just takes page 130. It
Or
should
close relative.
or guardian or close relative who in the event of executor being incapable of taking decision in the relevant time will be authorized to give consent or refuse or withdraw. Not in the concurring judgment of Justice Sikri and Justice, they use the word surrogate decision making. Or can we do one thing, Lord? Lord, can I suggest one thing? In
What
this,
will happen? We are just asking you this question.
no, I'm just suggesting one thing.
Supposing this person whom you name,
He dies, yeah.
he died. What will happen?
No, can
the
I
whole
do
thing
one-
will break down. Huh?
Yeah. No, Lordship will.
And he goes into
I
a
appreciate.
Alternate.
Appreciate. What I'm now thinking is marrying 198.2.5 into this. What we can do now is executor shall inform, as Justice Bose suggested, we'll borrow this language of 198.2.5. The executor shall inform and hand over a copy of the thing to his close relative and to his family members / close relative. Suppose he's alone. He has no family. Family members / close relative who in the event of the executor being incapable of taking a decision relevant time will be authorized to give consent.
Even then, this is a defective thing for, as it stands, because
If the person
think
dies.
of, supposing the guardian or the close relative die, what will happen then?
Then we'll have to add a paragraph.
What will happen then? And he goes into a limbo. I mean, he goes into
I know.
a coma. What will you do then?
Provided guidelines for where a person uses decision making capacity.
No. Then Lordship may add a paragraph that if the surrogate decision maker or so and so dies, then the advance relative will not be inoperative merely because the surrogate decision maker has died. That's all. So we can't provide for every eventuality. That's also a problem. That's why we've got income from other sources because we can't describe all this. Can I suggest one thing, my Lord? In 198 can do one thing. We can say that.
That is why we said that in the name of a clarification, we cannot.
I understand. Now, my Lord, what I'm submitting is
One suggestion we are just telling you, subject to what you may say. It should specify the name of a guardian or a close relative is what is mentioned. You can perhaps say it in the plural so that it will work.
okay. And whoever is there, somebody will be alive.
Whoever is there.
Appreciate. Perfect.
This is what we can think of.
No, it'll make it workable, bro. So that we don't have a situation where they'll say this person has died. Who can take advantage?
When we
Somebody
thought
will be there.
Can be.
Somebody.
Yes, somebody will be there. Lord.
Somebody will be there. Na?
Yes. So what we do is shall
So this can be, you have not suggested.
Or else order 5 rule 20.
can I put like, bro? Can you see?
Or close-
I'm suggesting cut off to the surrogate decision makers.
No, what we will do is 198.2.5, we will add just one S to guardian, making it plural, close relative S. Correct?
But it should be, are they named in the directive?
Huh?
They should be named in the directive.
That's what you're saying.
Correct.
It see, but just,
Your 198.2 will be added with the plural.
that's all.
That's all.
Yeah, just we'll read it out to you.
Yes.
You should specify the name of, instead of a guardian,
Guardian.
say guardians or close relatives to protect him, because even if he says only one where this contingency occurs, he'll be protected.
Can Lordship say, sir, guardians, can Lordship put any guardian or close relatives?
The name of any guardian.
Or close relatives.
Ideally, the person making this declaration, he should inform everyone.
That's what the Lordship.
Naming the person who can give the consent. So we'll make it should specify the name of any guardian or any close relative.
No, I'm just.
But again, it will be plural. Again,
Suppose I
it will be
make it
singular.
tomorrow, suppose we make it. Typically, I'll mention my wife or my son or my daughter.
Yes.
Yes, because they'll be the normally people who will be involved in, suppose something happens to the patient, generally immediate family will be involved.
That's right. So, I mean,
Your Lordship is right. We'll close it. We'll delete this. We'll borrow 198.2.5.
So, 198.2.5 will remain as it is. I mean, except for adding this.
This will be repeated here.
uh,
It will be repeated here.
198.25, it will be the name of guardians. I think it should be guardians
All right.
or close relatives. Otherwise, again, it will be singular.
Okay.
Any. So, we'll put it any name of guardians. Any will go or close relatives will take over and will be authorized to consent the auditor. Then it remains perfect.
Yes.
Then you come to 198.3.6.
Yes. But I'm requesting in the light of what Ms. Mehta has pointed out, records, if any, you can say that these records shall be, these are electronic records as prescribed by the National Digital Health Commission. That can be added. So it can't be any private record. It has to be only the, it can't be record of say Apollo Hospital or this hospital. It has to be the records as mandated by the National.
Which clause?
198.3.6.
We have to first finish that 198.3.5.
Oh, I see. That you have
given
Lordship
suggestion.
just now finished.
Huh?
198.3.5, the Lordship is striking off this, the entire surrogate and putting 198.2.5 again.
Modification.
So immediate,
With
family,
any
Yes,
under-
that is immediate family member.
No, 198.2.5 is, it should specify the names of guardians. Now it's only specifying the names. 198.2 is what the document should contain.
What should be done is,
Yes.
the GF is 198.3.5 because we have added guardians and close relatives who are named. First of all, they should come to know.
Yes, yes.
Most important.
Correct.
So
No, but
they should be informed. They
Correct.
should be. So we'll have to say shall cause to inform the
Guardians
or close relatives
who are mentioned in the advance directive.
who are mentioned in the
Advance directive.
isn't it?
Yeah, exactly.
They should know.
They should.
They are the ones who have to do it.
Correct. Because
Then the other thing can be, and other family members also. I mean, that also can be.
so 198.2 is preparing the document. 198.3 is
But there
informing the
again, we are knocking out the JFMC. Eh?
Yes, completely.
You're putting that responsibility on the executor.
Yes. Yes, because nowhere in the world your court is involved. Guardian Act defines who's a guardian.
But if the person concerned is not a Hindu,
No, I'm just defining. That's why I put guardians of close relative. Irrespective of religion, we all have relatives. So you don't have to worry whether it'll be religion neutral.
So here we are just, making it to you.
Yes. The executor shall inform.
198.3.5, we are making it the executor
Shall inform.
shall inform, cause it to inform.
Yes.
Cause it to inform. Shall cause it to inform let this immediate family members also know. Plus we will add the guardian because he need not be
You
the.
can also say the guardians, close relatives, and immediate family members.
Yeah.
Actually, they'll be repetitive because immediate family members are close relatives in any case.
They'll anyway know. That we are not, they are not changing that.
All right.
the district judge.
To the.
What about in the case of an orphan? Can we say that he is not having an right at all? Whether in that case it is JFM? Because we cannot say that no, he will not be having just because he is not having any close relative. or
You
guardian.
can't deal with every possible eventuality.
And we are already this
Correct.
this right.
No. See, the point is, as far as an orphan is concerned, once he becomes an adult and once he becomes a major, I'm just sticking to an orphan as a child.
Yes,
Right? Now, the orphan becomes old, he starts working, he marries, he has a family. Then he gets another relative.
That is why.
No, I'm saying if it's an orphan and if he remains unmarried, remain anything else, then yes. Then he'll have to put a surrogate decision maker.
Suppose he's a chronic bachelor or a spinster.
Correct, but he'll have a friend, he can say, my friend. My chronic bachelor.
So we're just reading out what we have done. 193.5 will read
Not one proper, I should mention orphan on a sideline. What is the caste of the orphan? I'm having a problem in Madras. He gets no benefit. Anyway, that's a different issue.
So we are just adding it 198.3.
Yes.
I'm having this problem right now.
The executor, listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5.
Okay.
And the immediate family members of the executor, if not present, that all will be made. What do you say?
Yes.
The guardian slash close relative slash immediate family member. But the point is, the whole purpose is they should know about it. That's how they know. That's all.
They will know about it. They'll take in, but then once a close relative is mentioned in paragraph 198.2.5 are brought in, and the other immediate family members, is it necessary then?
According to me, no. It's a surplus age. It's a surplus.
because he would anyway tell.
But just keep it what it is.
Normally, he will not tell his wife.
He'll be the purpose.
He will not tell his wife because wife will say, okay.
Putting it in plural, does it mean that it should be informed to everyone?
Yes.
No, only to the persons mentioned, the family members, etc., who are mentioned in 198.2, because they are to be named by him anyway.
Only named persons will.
The attesting witness need not be from them. So that this is why this will sort of give it clarity.
Very well.
So the other family members will not be then necessary.
Correct. Correct.
Then it'll be guardians / close relatives.
Correct.
To the extent that is what
Yeah, that's right. To the extent it's not.
and the immediate family members
There
also
are lost
then-
time. But coming.
Then may I suggest not reading
the brother
original.
judge who has authored, how much time he must have spent
That's
to
what I'm
find
saying.
out
And we are
that laying down the final modalities.
So let the family members also remain.
Then can I do one thing? Can I say one thing? Put guardians / close relatives. Forget immediate family members. Close relatives are immediate family members. Close relative itself means immediate family members. Who are my close relatives? My wife, children, etc.
No. The person who
Who are mentioned in the advance rate.
advances should be given notice. So that may not be a close relative. He may be distant relative.
Correct.
We don't know what all.
Can you also put it this way? The executor shall inform the person named in the
That's
person's
correct.
name in the close directive
referred to
and
as-
also his close relatives.
That's what we have said.
Yes. So he has to mention both to the person mentioned therein and also to his.
And what is the definition of close relatives in relative in section 56 of the Income Tax Act?
Yes.
That,
The Income Tax Act says lineal
No,
ascendants,
that's-
lineal ascendants and descendants.
that's right. We will have to
Companies-
go to the whole thing then.
Yes. But
So we are reading it out to you so that to make it.
No, and Companies Act defines relative.
Listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5 and his other immediate family members
Yeah.
of the executor,
That takes care.
etc.
That takes care.
That will do. Then anything else?
Instead of close relative, near relative may be mentioned because near relative has been defined in the Transplantation of Human Organs Act 1994.
That's a good idea.
So we may mention near relative because this is statutorily defined
But
in
this
the
is
law.
what this court has already pondered and thought. Let us not, create a complication.
No, I would request, please follow this because near relative is defined in the
They're
Act.
telling you this is what the 5 judges have thought it fit to. Let us not tinker with it only to the extent that it is necessary. We are doing it. Yes. Then 198.3.6. What is it?
Yes, I want your lordship to, I'm requesting your lordship to add at the end of if any, these electronic health records will be those that are maintained under the
198.3.6.
3.6.
A copy shall be handed over to the competent so and so or the so and so. You want to add this also?
No. I want to add, instead of putting panchayat, etc., I'm saying if any, I'm suggesting there is a notification dated 30th December 2016, number 1100 of 2015, notification of National Electronic Health Record Standards. So now lordship will kindly just make a statement. Can you put it like this? The electronic health records will be those maintained.
So this is in addition to.
Yes,
The suggestion
yes, because the
not to
digital
do away
records.
with it. Not to do away with what is already there. That you don't do. You only want to add, executor may also choose to incorporate.
Yes,
May choose to.
yes.
The advance directive in their existing electronic health records, if any.
If any.
That, what do you say? That can be identified.
If something is available, it's
That's right. Let that be added. We are not taking out anything.
let us not make it mandatory or this one is left.
It is left to him.
Yes.
So this will be added to this. What is already there, we are not deleting.
No, my lord. The point.
Copy shall be handed over to the competent officer. That is a safeguard which has been put by this court.
Who's the competent?
Okay, leave it.
No.
Competent officer, the local government means secretary. Who is the person, if you want us to make it clear?
No. Now the point is, the aforesaid authority shall nominate a competent official in that regard who shall be the custodian of the said document. Now, once I'm putting my document in the electronic health records, and that is a statutory notification, why should I again go to?
The record, who shall be the custodian of that record?
Yes, but I'm saying the government of India is now having, we are a digital age. The government of India is providing for a national
You're
digital.
saying this is one by way of, hard, it's a physical document you're having it. The other thing, you may do it if you wish to.
All right.
So if the hospitals may want
No,
to.
actually, this ulta is the situation. Handing over to the corporation is a big problem.
What is the problem?
There is nobody nominated.
We'll make it
Not after Vishaka came for 11 years, nobody drafted the laws.
the secretary to the concern, because local department is panchayat, etc. The secretary is usually the
National
executive authority.
Become impractical, my lord. Nobody hands it over to the government. Why do you
There's
advise the
nobody, what
government?
they say, there's nobody who's competent body.
No, it can be this or that. Additionally, you can put this National Digital Health Mission thing.
Let him do it.
Ah.
That's what he
But it could be either. It could be either.
Yes. Or the person may nominate, give a copy if he wants.
Could be either, because otherwise, that National Health Mission thing is ultimately going to work.
That is electronic,
Yes.
electronic health record.
Yes.
And even they only want to choose to incorporate it.
No, it's already
What this
notified.
court has found that it should go into the
No,
panchayat.
that's why,
It is-
all right, both.
Both, that's what I'm saying.
Both,
Let
both.
both remain. And if you want, we can say the secretary. Instead of the competent body,
Then can Lordship put it, instead of copy shall be handed over, copy may be handed over.
then what is the record?
Why you want a record? Why do you want the record?
Then we'll be completely changing the scheme of the.
Then you can just put copy may be handed over.
No. Shall
Or let it be there. Let copy be there. It's not working. I'm telling you, Lordship, there is no.
just handed over.
Handed over whom?
Yeah.
Handed over to whom?
Secretary, we are going to say secretary, we'll make it clear. It shall be the secretary. Because he is the person who should normally accept it. Can we say secretary?
Going to be
The local
unworkable.
body.
Or else would it be the alternative? It's only my thing. Can be some local registrars. There are all the records will be maintained in the registrar office. If it is to be done, I think something can be.
Please don't send them to the registrar's office.
Very lively.
You know what happened.
I know that.
Don't send any one of these people there.
So all the records are normally maintained in.
Even panchayat may not be much different.
But Mr. Natarajan,
Yes.
if this notification is issued,
Yes.
National Health, Digital Health
Yes.
thing,
Yes.
it is better you keep it, if it is connected and integrated with all the hospitals.
Coming, we are
That will be definitely, that will take some time. The process is.
It's already there, notified.
No, actually, what happens is the red is only 10% of the whole.
I am,
192
Mr.
is not.
Natarajan is saying it's all
Different
notified.
paras are not touched.
We'll check it out.
Lordship sees me not
So,
to avoid the.
we see brother. A copy shall be handed over to the, this is something which has been thought of by the default, by the bench.
Included,
We can add that.
including so and
This should be retained
Mr. Datta, I'll tell you one thing. Whatever the exercise we undertake with your assistance in all, nothing can be made absolute. Nothing can be made absolute. So, our only request is whatever the difficulty the people have faced in the given point of
Correct.
time, to that extent, we may take a call and clarify. Rest of the thing which has still not been operational, people have not come across those hurdles. Better not to tinker with the moment. We can't visualize how the things on the ground will work. So we want to make it, your anxiety and our anxiety is that it may work on the ground. So whatever the difficulty the people have faced to meet out that situation, whatever the alterations may be.
Yes. Instead of going on imaginary things at
Yes,
present,
that's
as
right.
in the situation emerges, we can take a call. These are all the
This court can always.
might happen. It might be the problem.
Simply make a law tomorrow. All these problems will be
The
over.
judgment also it said that the directive and guidelines shall remain in force till Parliament brings a legislation.
Important legislation.
So come up with that.
So we are saying this it will remain. So should we say the secretary? Brother, should we say the secretary?
Or can I suggest one thing?
What do you want?
Copy shall be handed over to a competent officer of the local government or corporation or panchayat as may be nominated, whoever is nominated. Because now the point is this.
That is already there.
No, local government or municipal corporation or panchayat as the case may be.
No, next sentence you please
The
read.
aforesaid authority shall nominate a competent official in that regard who shall be the custodian.
So it's very clear, this court has thought of it, not as if this court didn't think of it. So we will only add this other thing, that red will come along with it. Correct?
Okay.
Then next is para 198.3.5 is to be deleted, you're saying.
Point seven.
JFMC's role is
Yes, yes,
family physician.
yes,
And that I don't think that can be deleted. Eh?
yes.
Okay, deleted. That is deleted.
198.4.1.
Then 198.4.
Now we come to the implementation stage.
That's right.
198.4 is the implementation. Yes. And there we get, my lord, this is where, my lord, we have, this is in consensus with the health secretary and the AIMS, my lord, 198.4.
That's right.
Yes. In the event the executor becomes terminally ill or undergoing prolonged medical treatment with no hope of recovery and cure, my lord, this I have added on the basis of Justice Chandrachud's judgment, para 475. He has added 3 factors if your lordship wants to see that para 475, if your lordship wants to see it, so that it's not my addition. And this is also mentioned in the ICMR record, permanent vegetative like Aruna Shanbag, persistent vegetative state. And when you say the treating physician shall assess, this is the primary board.
So you're adding vegetative state.
Yes.
Okay.
Lord, what Justice Chandrachud used, persistently unconscious condition is added at page 475 of the judgment, page 251. Page 251, para 475, 474 and 475.
So you can just add this. Or is in a persistent vegetative.
Then brother is saying in that is in a or is in a persistent vegetative state, we can perhaps consider that. The other portion we can't be adding. We can't be adding it. We completely, it requires a lot of thought. We can't be adding it. Or in the state, with the state of initiation, you will give, so much of discretionary power to the doctor can be capable of being misused, and we don't want that. So now the question is whether we should add or in a persistent vegetative condition. What is your view, Nataraj?
Before Lordship
It would be, I think that can be. He'll not be able to take any decision, and it is
Covered actually in the earlier.
in the earlier one. It's covered actually.
Para 470.
Only it is only the explanation.
No, but what do you mean by persistent vegetative condition? Supposing there is a possibility of his being brought back.
Lord, it is defined by the Supreme Court. Persistently unconscious condition. Is a
Vegetative condition.
No, same parameter.
Ah.
Is an irreversible condition.
Irreversible.
Just 1 minute. With no hope of recovery and cure, that
Yeah.
is fact.
So what will happen if he is in a persistent vegetative condition? The life
Yes.
support system has to be withdrawn.
Yes, because is an irreversible condition in which thought and awareness of self and environment are absent. This is the concurring judgment of the Supreme Court.
From where are you getting it?
Para 475 of the Supreme Court judgment, concurring view of Justice Chandrachud, in the same judgment.
Then you'll be adding it to the view of the majority judgment.
No, I'm just trying to, because
That will be basically,
no, but what I'm saying is,
so many.
That's our request.
That is not.
no, but the otherwise judgment is confined to terminally ill alone.
That's it.
What about permanent vegetative state?
I don't know, it should have been done. It becomes a complete revival.
No, it's not revival.
Will not expand that. Will
Siddharth,
confine only to
Our request is
situation.
only one. To the extent the difficulty have been faced in getting particular directions of this court implemented in individual cases on ground, to that extent, because what has been expressed in 98 and all, it is a collective decision of all the 5 majority. And all have agreed to it. There may be suggestions given by other concurring views, but the final suggestions acceptable to all the constitutional bench is this.
That's right.
And from here.
Another thing, these conclusions are based on the discussions.
Yes.
Now here, if we are changing the discussion, this decision part only,
Yes.
without any discussion,
Yes.
Leave it.
then we'll go against
Leave it.
sometimes.
We have spent so much of time on deliberations, but if your lordship feels it's not possible for a permanent, not a person like Suna Shanbag, who is not terminally ill. He's in a coma for 9 months, 1 year, 2 years, 3 years. I leave it to Lord. I don't, if it's not going to be, we're only trying to make it as helpful to the patient.
Legislation comes. They also, day in and day out, legislation also come. And the legislator in their wisdom also think that it will work, but will never work on ground. And that's why amendments are made and we also sometimes intervene and shut down. This will always continue and there can't be an absolute system at all.
No.
Whatever the system can be made workable and we are able to get the acceptable results to the extent possible that we achieve the target.
I'm only saying we should not lose sight of the forest for the trees. What I'm submitting is, the idea is a person, he makes an advance directive, he is in a position he can't take a conscious decision. His chance of recovery is completely gone. There is no chance of him coming back. That's why the Supreme Court has said permanent unconscious condition. The ICMR uses the word permanent vegetative condition. He's like a vegetable. He's brain dead. Now there's a definition of brain dead. As Dr. Kishore mentioned earlier, the definition of death was the heart doesn't function, lung doesn't function. Today, the person's heart, lung may function, but his brain dead. The stem is gone. He has no chance of his recovering at all. He can breathe, he can pass motion, he can do everything. I'm only requesting now, since the Lordship is modifying, is the Lordship changing the judgment? I don't think so.
Make it workable.
Yes, just come to 198.4.2.
In the chart, Malak, or in the judgment?
That's right.
In the chart, Malak? Yes.
I mean, 198.4.1 to begin with.
Yes.
When and by whom can it be given effect to? Just read that.
In the event, like the Lordship asked you the original judgment, no?
That's the original judgment. We have to read that.
In the event, the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, the treating physician, when made aware of the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdiction JFMC before acting upon the same. So now
there are two key elements. One is he becomes terminally ill and with no hope of recovery and cure of the ailment.
That's a terminally ill ailment.
This is how you begin, trigger the sort of process. And then 198.4.2.
The instructions of the document will be given due weight by the doctors. It should be given effect only after being fully satisfied and the executor is terminally ill and is undergoing prolonged treatment or is surviving on life support and the illness of the executor is incurable or there is no hope of him being cured.
So will it not perhaps cover all this, what you are talking about?
No, the difficulty with doctors face was terminal illness is just one part of where there is no hope of cure. It could be a person who is not terminally ill. He is not ill.
Why were you not able to persuade the court to hold?
But the matter was reserved for a long time. I don't know. We argued all these points. The written submissions are there.
Oh.
We gave the ICMR. We gave all the directions.
Can't help it, they should immediately find a review.
So we may still choose to file a review. That's a different. Take instruction on that. We file a proper review. There's only limitation is the problem. Not condone the delay.
Limitation. Nobody who will look into limitation. That's a matter.
What do you say?
I don't think we should touch these issues in the present.
Issues.
Not in these proceedings at this stage.
That was argued.
Not on this application or anything. Virtually, we are
We are not on that issue of whether review or miscellaneous application or clarification. Ultimately, we are sitting in this combination to see what to make it workable.
Workable.
Not on the technicalities.
That's right.
The jurisdiction is not.
That's right.
Not
That's right.
jurisdiction. You are in a clarification jurisdiction. That will not come here.
But as and when the practical difficulty comes, we can think of that.
That should be right.
On imaginary grounds or imaginary situation, we need not do everything. Even after doing so many exercises, there will be again further there will be some more clarity.
Just see page 251 of the judgment. Page 251 of the report. Just see that for a minute. Page 251.
Yeah.
Because Lordships have held that the law under Article 141 is the law also mentioned by the concurring judges. Now, please see para 474 in page 251. Lordship has got that?
251.
Of the reported judgment in the SEC.
I'm also informed that the vegetative is a subjective term, it's not a medical term, I am told, by the doctor. So it will lead to a lot of
No, my lord, it's part of the
A
ICM.
lot of,
Yes.
possible.
possible
We
inter.
don't know.
No, please see para 4. I'll leave it to Lord. If you want to drop it, I don't mind. These are
How do you actually define a vegetative condition?
please see para 474 and para 475. Please see that. Kindly see page 251.
Lord, can I define PVS? Permanent?
PVS, it's a medical
Yeah,
term.
permanent vegetative state is different from brain death, is different from coma. Permanent vegetative state means when the cognitive functions are intact, except the responses. The person is listening. There are eye movement. Person sometimes smiles also. Person sometimes weeps. The person is passing urine. Person is passing stool. Person is perspiring. Person is digesting.
Yeah.
Person's beard is growing. So the person is very much alive. The only thing is that his cognitive function is lost to a particular extent of perceptivity. Not even to respond to those perceptions.
So will such a person be able to signify, if not through words audibly, through signs? I mean, please take it off.
No, he cannot. Sometimes
He is not in a coma.
And he can't respond at all.
he cannot express himself. While in the brain dead, the person is dead. He is not perceiving of.
We follow. Now, in the case of a person who goes into persistent and a permanent vegetable condition of
PVS.
That's right. Are there cases where they come back?
Yes, they may come back even after 20 years. Because then I have filed a list of 20 cases when I argued the matter before the Honorable Justice Deepak Mishra Sahib.
So there is a possibility. Why we have asked you that question?
It's a very much viable possibility.
Oh,
Persons have returned even after 20 previous automatically.
therefore, we will.
We cannot say that the person is condemned to die.
That's right. So what are we talking about? We are talking about somebody in his pink of health, or perhaps lesser state of health. He making a call. We taking a call. If I am terminally ill and there is no chance of my recovering, these are the things. Please don't trouble me. I am prepared to go. As contrasted with that, this is a case where it's not a case there is no chance of recovery, as the doctor says. It's possible that he may come. Now, who does not want to live a little longer if it is possible? But for the terminal cancer patient, everybody wants to see a little bit more. Where will he go? We don't know. So,
Well, as it is said, everybody wants to go to heaven, but nobody wants to die.
exactly. So this is a very contentious area. I personally would not want to.
Drop it, Malad, drop it.
That is why yesterday also I had submitted that.
What is your stand? What is the doctor's stand about this vegetable condition being added as a condition?
No, clear no, very clear no.
It should not be.
It should not be.
Drop it, Malad.
PBS
Look at
has a very uncertain outcome.
Malad, the Indian Council on Medical Research has said it should be a condition.
That does not go there.
Yes.
Because if I
Malad, let's not waste it. Take a lot of time. Malad, just put terminally, let's leave it, Malad. I don't want that.
That's already there. So let us drop that.
No,
That is instruction for me also.
Malad,
That is instruction for me also.
So it is very contentious.
I took it because the concurring judgment says there are three conditions.
I mean, let us not go.
Leave it.
So that's the end of it.
Yes.
So 198.4, the only difference we will have is that JFCM part will have to go. My learned brother was pointing it out.
Yes. No, and Lordship will say in 198.4.1.
You did not notice it. 198.4.1, please read. When made aware of the
I deleted the bar.
the genuineness from the JFC,
No,
that will go.
Next page.
Next page, bottom.
Well,
Page struck out.
Next page.
next page.
Below
There
page 5.
itself. In the black. After red, black. No, next page. There itself. After red, black.
Lordship
Next page is this one.
Page 4. Please see page 5.
Oh, you have deleted it.
Yeah.
Okay.
May I request your lordship to cut off that vegetative state there, in that reading?
Yeah, we are cutting it.
Yeah,
off.
cut.
We are not going to take it.
The entire reading, you are cutting it off. Persistent vegetative initiation, all that your lordship is cutting it out.
So then 198.4 will entirely will go.
No. Only the first part. The treating physician shall ascertain whether the patient possessing. That's part of the health ministry's also guideline that they must have a primary board, secondary board. All that is there.
So, shall 198.4.1.
But earlier what happened? The JFMC.
Shall ascertain the genuineness.
But earlier what happened was the decision to pull the plug was with the judicial magistrate. So JFMC will take a decision on the authenticity and genuineness. Now we are saying the JFMC has no capacity or no time to decide with the genuineness. It has to go to the primary board, medical board. That is also the view of the health ministry.
No, that now the treating doctor will actually find out about the genuineness from whom. If you delete the JFCM, from whom will he ascertain?
The primary board, no, that's coming next. It's the primary board of treating physicians and one independent doctor, the 3-member committee.
What?
Not yesterday, we gave a chart.
The primary board has got nothing to do with authenticity of the
Document.
advance directive.
That will be done by the primary team now. They will know there's an advance directive. It will be part of the digital records.
What you are saying is, kindly read 198.4.1. In the event of the executor becomes terminally ill and is undergoing prolonged treatment with no hope of recovery, cure the ailment, the treating physician, when made aware about the directive, shall ascertain the genuineness and authenticity thereof from. This is a sentence which you will have to delete. Shall. So then he will, the treating doctor will find out about this. He is made aware of it. Let us see how it imagine it. It's being brought to his notice. This is there.
That's all.
So what this court intended was that it should be made aware. The authenticity should be established from the JFCM that we are deleting. So he should be made aware from about the authenticity of from whom. Because we are actually given that task to the notary or the gazetted officer.
That's only for maintaining records.
No. They are the persons who will be doing that verification. You see, 198 point, kindly come to 198.3.1. We have replaced the judicial magistrate with the notary. So when the treating doctor, he will have to ascertain it from the concerned notary public or the gazetted officer.
Or the close relative also.
Right?
Or the close relative also. What you will imagine, not a person is in the hospital.
That's right.
Now the doctor has to decide, is he going to go to the notary public?
That particular relative is very keen to knock off the person.
Possible. I'm not saying no.
So then how?
So that's why the National Digital Health Record is there.
What if he doesn't make use of that? If not everyone who is
because there's no directive.
So therefore what you're saying is why not replace, we have replaced the JFCM
Yes.
with the other man, that is a notary at your instance.
Yes.
So he can ascertain from the notary public.
Only there's a doubt about the genuineness.
That's it. I mean,
Yes.
this is what.
Correct.
Otherwise, we will be knocking off this.
That's what I'm saying. So the point is, because if there is a doubt about the genuineness,
ascertain the genuineness and authenticity from JFCM will be knocked out. From
the lordship is when it says that the health team has to go to this gazette office, the notary public, and find out the document is genuine or not.
Going by the decision.
Possible.
This should be done before acting.
We might as well close it, brother. It's not going to work out.
This has to be there, Datta. This is a part of the.
How can the doctors go to the notary public and decide? It's not possible.
No,
Not like the Apollo Hospital situation.
I was just going to say, suppose you are keeping it in the digital format
Yes.
with the National Digital Health Mission,
Yes.
the district portal, whatever it is. So it would be much easier for the doctor or the treating
Once
or the
it is
relative.
part of that, it is presumed to be valid.
If there is a digital format documentation
It's already there.
with the National Electronic Health,
If that is done.
National Digital Health Mission.
then that is an authentic thing. I
If
mean,
that is done, he need not.
that's right.
But if it is not done by.
So that option should be given here. Instead of, JFMC.
you have to rewrite the whole thing.
No, that could be an additional thing, either here or there.
Lord, all over the world, all they see is a directive signed by two witnesses. We have to, doctors are saying,
Made
please
aware
trust
of
us.
one
It's not that a person is going to be start fleeing off.
genuineness and authenticity from the, what we will do is from the testimony. Getting appropriate.
But let's see, it's 198.4.2 also before.
So what we can do is,
Yes.
because in 198.3.6, we have said the executive may also choose to incorporate the advance directly in the existing electronic health records. That is done by him. That's a digital thing. He can ascertain the genuines with reference to any existing to
Can I put it like this, Bro?
advance.
Can I put it this way, Bro?
Entered in the existing electronic health records.
What is the precise thing, just so that it gets?
I just don't interrupt. I'm suggesting.
In the absence of the same, the genuineness shall be ascertained from the notary public or the, what do you call it? What is that officer? Gazetted officer. Refers to paragraph. 198.3.1. 198.3.1. So that is what we are proposing. We'll read it out.
Yes, yes.
198.4.1 will read, in the event the executor becomes terminally and is undergoing prolonged medical treatment with no hope of recovery and cure the ailment, the treating physician.
Actually, the treating team of doctors. So putting physician, they should not tomorrow say physician is different, surgeon is different.
Isn't that? Treating physician, there will be one physician at least. Yes. When we are talking about MD and all that, it's not that. It's a treating physician.
Okay.
When made aware of the directive, advance directive, shall ascertain the genuineness and authenticity with reference to any
Electronic health record.
any entry in the electronic in the existing electronic health record, if any.
Or with the custodian as mentioned in 198.3.
That's right. That is.
Or with the custodian.
Or with the custodian. That
as mentioned in 198.
Or with the custodian. So that's the simple thing. Then what else is there?
Now this is the main thing where all of us are agreed upon.
Oh, the main thing is coming out.
No, this primary board, secondary board.
Okay.
Yes. Because in most jurisdictions there is no board. Because even the concurring judgment says that once I have given my advance directive, it's called subjective second standard. That is, I have already given the directive, so don't now second guess me and reconsider it. But we are putting safeguards that just because the directive don't do, let it be subject to us. In fact, I'm told that primary board is contrary to a principle of advance directive. Please come to 190.
And 198.4.2.
Yes. If a valid advance directive exists, the hospital where the patient is admitted shall constitute a primary board consisting of 3 doctors on the patient's treating team. The primary board shall satisfy itself that the executor is terminally ill and is undergoing prolonged treatment and is surviving life support, or illness is incurable and there is no hope of excellence. You can cut off permanent vegetative disorder. Please cut it off. This is from the ministry, this particular paragraph. That's all. Only, please cut off only permanent vegetative statement or is in a permanent.
And the other thing also, initiation, escalation, all that, that will all go.
That's also not necessary because it's no hope of being cured. That's enough.
Take care of everything.
Yes, yes, your lordship is right. The whole thing.
Therefore, now what is the existing 198.4.2?
There is no board brought. So the ministry suggested that there should be a primary board.
198.4.2, 98.5. Instructions in the document are given due effect by doctors. However, it should be given effect only after being fully satisfied with the termination and so on. What is
Who will be satisfied?
Huh?
Who will be satisfied? So primary board.
Yes.
It was silent as to who will be satisfied.
Without directing. This is matching.
What says is only the doctors. Which doctor? There is nothing. It's very ambiguous. Therefore, it is said that let it be by the board, properly duly constituted.
See, that is made clear in the next one,
Yeah.
198.4.3. Because this is kind of a general thing. So what is to be done by the treating doctor is, if the physician treating the patient is satisfied that the instruction given in the document needs to be acted upon, he shall inform the executor or guardian, close relative as the case may be, about the nature of the illness. No difficulty. The availability of medical care, consequence of alternate forms of treatment. He must also ensure that he believes on reason whether the person understands where it's a coincidence or concerns. So this is what the treating doctor should do first.
For which state?
Correct? Then the physician, next is 198.4.4. It is very carefully thought out. The physician hospital where the executor has been accredited for medical treatment shall then constitute a medical board consisting of the head of the teaching department and at least 3 experts from etc. Who in turn will visit the patient.
That's the 198.
So what is wrong with
No, 198.4.4 is unworkable.
Why?
It's unworkable because head of department, at least 3 experts from general medicine, cardiology, neurology, nephrology. We simply saying, not this, the Ministry of Health also agreeing that this is completely unworkable. Just have a primary board.
What do you mean by primary board?
Primary board is the first board which takes a decision.
What is the composition of the
Composition is the treating physicians plus an independent person. That's what the ministry says, bro. I have no problem. And as the Lordship pointed out, where is hepatology, where is pulmonology?
I withdraw it.
Review.
My lack of knowledge, that's all I can say.
No, I'm not. This 198.4.4 is.
Why do you say it is unworkable?
That's what doctors tell me, my lord. Now, please read it, my lord. The physician hospital where the executive has been admitted shall then constitute a medical board consisting of the head of the treating department and at least 3 experts from the field of nephrology, etc., etc. Then there's a further direction that it should be 30 years experience. All those things are there. We are simply saying make a primary board.
These are all value judgments which have been.
And one more thing in our application,
We'll change the judge. What my brother says, we'll be changing the structure of the judgment. It was carefully, when you said it was reserved, a lot of thought would have gone into it.
I'm just pointing out it's
Right.
not going to be workable. It's not going to be workable.
Practical difficulty.
So the whole exercise of
to
the
make it more easy, more smooth.
I'm
But,
saying when
No, one thing
doctors and the health ministry
is 198.4.4. Such a board just envisage in any hospital. Such a board, just the nomenclature of the board that is given. Try to think of existence of such a board in a not Kerala, but in a other Mufassil hospital or something. Such a board cannot exist.
No, you will have a hospital where you're going to see. First of all, we are.
No. We are looking at the
We
patient.
are talking about, ordinarily, nobody will do this, first of all, to begin with.
No, that's
We have to begin with a certain socio-economic strata of people who would want to do this. Let us take it that they would go to what the court contemplated. That they would have this facility. If you want what we can have, they can always call for experts from other hospitals. It is not necessary that the expert need be working in the same hospital. You see, what you're saying is we are
Lord, my friend points out that these guidelines are not only for advanced directives, but also where no advanced directive is made. And I've given in my paragraph, in affidavit, I've given 7 paragraphs why this is not workable.
Well, then constitute a medical board.
Yes.
And so consisting of the head of the, that is goes.
No, that's
Head of the treating department will be there. Every hospital, if you are going to have some major, if you are going for oncology,
I mean, before
no, we just, I'll give you an
no,
example.
because at least on this point, ministry also wants change, my lord.
We are not going to think that the ministry is always.
No, I'm saying this is thought of by the
Okay,
games.
kindly
Sorry,
bear with it.
I'm
Kindly bear with it. Let us read together. Shall constitute a medical board consisting of the head of the treating department. Okay. Now we are talking about a terminal illness, no hope of cure. I mean, no possibility of cure. Now let us take oncology. You are contemplating a situation where the oncologist, there will be a head of the department. There will be somebody who in every hospital who will be designated as the head of the department. That person will be there. So then comes.
In many hospitals, there may not be department, there will be just hospital, 3-4 surgeons.
Go to a
45-bed hospital, 30-bed hospital.
You should go to a hospital if you want to get all this. You should go to a hospital.
No. I mean, if we go to a hospital, I will go to a nursing home which may not have heads of department.
Then what should you? How would you verify all this? If you are going to say, I want to get if you want to say that I want to get the benefit of the judgment, and I go to a nursing home where you just have an MD.
No. I'm saying you may not have departments of oncology, neurology, cardiology. That's what I'm saying.
Get a doctor from outside. We can make that clear.
I don't know.
No, but is that
No,
we are
which-
telling you
which
find
doctor
something
gave it?
inconvenient. You're taking away somebody's life support virtually. You're going to say that please make it even more convenient so that I can go.
Take
I'm
away the
not saying
life of
that.
some other,
I'm saying that.
so that I can take away the life of some other person.
Some other person.
So I'm only saying
What
primary
is
board and
that?
review board.
Is he correct in saying?
So I'll show that
What is your suggestion about?
Actually, the department wanted to have board in a particular place. Board should be there instead of giving a very vague expression that it should be by the doctors. See, they wanted it because we are,
That's right. The health condition
Yes.
requires a multidisciplinary
yes.
examination.
In different conditions, different situations, we can't visualize at this stage. Therefore, they wanted a board, that's all.
That's why the court also thought of a medical.
Yes.
So that they should go to a hospital where these facilities are available.
Yes.
You cannot simply go to one clinic and say that this.
We can't, yes, we can't do it.
To get the benefit, you will have to go to such a hospital.
It's a hospital.
Consisting.
But
Because the thing is that you are actually taking in the life of one person.
correct. You are taking away somebody's life.
So like,
No light.
continue tomorrow.
No, you continue today.
Okay, please.
My brothers agree for some more time we can spend so that we can maintain. If you all agree. And close it.
You see the entire list.
Tomorrow anyway we don't have any. No, not saying that. Right now it is 4:30. Take part. That will be over. That's all we want to know.
The suggestions are ready. Definitely it is going to take another hour. That's what I feel.
You want to go somewhere?
No, I have no problem. I can sit on 6 or 7. There's no problem. But
Suggestion in this particular.
No, that is, Doctor, you have given very invaluable suggestions, including particularly the vegetable condition. Your suggestion was very crucial. So let us first be done with him, and thereafter we will consider. What you say? What is the about this medical board? Do you have anything to say?
Yes. I'm talking only precisely on this particular point. So the medical board should be of 3 doctors.
Yeah.
Number 1, the treating physician.
correct.
Number 2, the superintendent or the director of that particular hospital. And number 3, a specialist from the specialty concerned. Suppose there is a patient suffering from carcinoma, we can call an oncologist. If he is suffering from renal failure, we can call a nephrologist. If he is suffering from neurodegenerative disorder, we can call a neurologist. If he is in deep jaundice, we can call a hepatologist.
I'll give you a practical example. I'll give you a practical.
Even the practical an example, only 3%.
No, doctor, I'll tell you, give a practical example. I know there's a hospital in Kerala where I used to go. That the medical director, he was a MD in medicine, but he went and studied in CMC Vellore, passed out from Vellore. Supposed to. He was designated by the hospital as a medical director. He was not a super specialist at all. In most hospitals, you find, even present man I know, he's an MD in general medicine. Maybe maximum exam DM. Correct? Now, if the treating physician is also an MD in general medicine, so you will end up having, out of the three, you will have 2% with MD in general medicine. So the whole point of having a multidisciplinary board, which was in the mind of the court, that will be lost. You see, when you talk about a genuine multidisciplinary board, the whole idea is you're taking a very vital decision affecting somebody. So they wanted this court intended that all these disciplines are those disciplines where you could have the possibility of a terminal illness becoming so bad that you need to have all these relief. So that is why, I don't know whether we should tinker with it. You can add something more or something.
I think doctor's suggestion of having a team of 3 doctors makes more sense because it simply says the treating doctor.
Not the medical director. Not the medical director. You may have nothing to do with
Depending upon the terminal ill. What is the terminal ill that we will have to?
No, because we want
what kind of
odd number. An odd number. One is the treating doctor. I'll put it this way. Typically, if a person is having cancer, now if he is in a reasonably good hospital, he'll be treated by an oncologist. So already the treating physician is an existing oncologist.
He'll be the head of the department.
Yes, so what the ministry also suggests,
He'll be the head of the department.
may not be, he may be a junior doctor also. We don't know, a large hospital. But he may be a junior, I may have, large hospital may have 5 oncologists. Everybody may not treat me. The senior most person may not be treating. So
if a junior doctor is,
no, we are just talking about safety mechanism of safety.
if a junior doctor is treating him, it will be very, very unsafe.
No, I'm saying he will be 20, he may be 45 years old. He may not be 60 years old. He may not be the head of the department.
That's right. But
Yes.
if you have somebody with greater experience,
Yes.
he will take an independent look at it. See, the treating doctor may have a particular view.
But this 194.4 is not going to work because you can't have because time is of the essence. The person is terminally ill. He's brain dead. You
Many of the major hospitals in Chennai, you're familiar with, Bombay, can you say that this will not work?
But we're not doing for not for the big hospitals.
No, I just want to say, I come from the northeast part of India. I can visualize only the Guwahati Medical College and 2 other medical college having this kind of a
Throughout
situation.
Northeast. Correct. Throughout Northeast.
Throughout Northeast. Other 6 states will not have.
Uttarakhand also is like that.
Not a single hospital
Uttarakhand
in the government sector also. So therefore, this is not workable.
Sorry, but many people are coming. Lordship perception, it's only by a small class. Many people would want to do this once they know it. And the Lordship sees in many towns also, there are chartered accountants. Even in a small town, there is a chartered accountant, there are advocates, there are professionals, architects.
Who want to be.
Who can take advantage of the advanced directives.
So they should go to that appropriate hospital.
Not to a clinic and then
No,
take away the life of a person by sin. So you will have to visit to a particular hospital where some such facility and doctors.
Just imagine a junior government servant. His father has a cerebral stroke. He's terminally ill. Now, are we going to tell him that no? If you want to have this advanced directive, you must go to Apollo Hospital and
Not
go there.
Apollo, not Apollo.
Government hospital.
These facilities, we cannot say that these facilities are available only in Apollo.
No, but I may say, let's say, for example, suppose I'm staying in, say, GK, Greater Kailash in Delhi. My father has a stroke. I take him to that local hospital where 25, 30 beds are there. There is a team of physicians. He has made an advanced directive. They don't have a team of oncologists, nephrologists, they don't have. They've got a team of doctors who are doing it. They get treated. Suppose it's only a cancer hospital. They have no other department.
Lata,
The point is, what is the purpose? What is the purpose of it? We are having a prime first.
Lata, you kindly come to 198.4.4 once again. Does it anywhere say that the members of the multidisciplinary team should be of that particular hospital?
It makes all the more difficult.
No.
Please see
You're saying it.
Please see the feedback of the doctors.
Ordinarily, you would when you go to a particular, when you're talking about terminal illness, and you're diagnosed with, you're getting this treatment, It will be in a hospital where these facilities will presume it is not. We assume it is not there. We are
Suppose I'm in a
correct.
northeast state, sir.
So we are correct. We assume it is not there. Just see what it says. A medical board consisting of the head of the treating department. I think that there is no difficulty with that. And at least 3 experts from the fields of so-and-so, 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 with overall standing, who in turn shall visit the patient in the presence.
Correct.
Now, they would not be drawn from that hospital. We are trying to tell you. If you want, we can clarify that.
I've got 3 affidavit. Doctors have said this is not possible because suppose I'm a.
They don't want to call doctors from outside.
But they have to leave their work and come here. And the 4 people must come. They must come at a particular point of time.
No,
But I'm just saying, no, let us see from the perspective of doctors, not from what we hear.
One thing I suggest, Datta, you think if we reduce the number of members of the board, make it workable, one thing. The treating doctor and 2 other experts to have a board to examine.
And that's the primary board.
Primary board. Leaving apart oncology, this. Expert means the director, the person who constitute the board, keeping in mind who are the experts in relation to the sufferings of this patient. And accordingly, board will be constituted.
Right.
Not possible.
I'm telling you, Justice Joseph is asking you can call doctors from other hospital. I'm looking at a scenario where in the entire town or the city, in a given hospital, this is not available and forget about getting somebody from outside. Experts are simply not available. I'm talking about a scenario which I am familiar with. It may not be replicated all across India.
I am also suggesting to myself, if a person has got say 15-20 years of practice, I mean any good doctor, anybody knows that this is a person who's terminally ill. Suppose the cancer report says he's got the 4th stage. It has metastasized. It has gone all over the thing. Then do we need 4 doctors from 4 teams to come and opine and all that?
We do not know.
That's why they say terminally ill. That's why they say terminally ill.
Well, the decision is also very critical.
No, the point is, how should the board be? That's the only question.
And why should we also distrust the doctors who will be opining as to the condition of the patient?
Please see the affidavit which you prepared. Manoj. I spoke to doctors from Bombay. I spoke to a panel of doctors from Madras. They had a meeting in my office. I went to Madras Medical Mission. I spoke to the doctors. We took all the trouble.
So what
They say, look, it is impossible. Even in Apollo Hospital, where do you get the time to call all the team? They will summon the team. Director will come. Everybody will come. They will meet. Then you get a further report. It's not possible. And how many people go to Apollo? How many people go to?
Task is a serious task also.
Can I suggest?
Whether make somebody
Let us
leave
read
or
once
Sorry.
Mr. Datta,
Sorry.
let us read.
Apology.
The physician stroke hospital where the executor has been admitted for medical treatment shall then constitute a medical board consisting of the head of the treating department and at least 2 experts from the field,
Monkey must have gone. Yeah.
then leave it with overall standing in the medical profession who in turn shall visit the patient. All these
20 years, etc. is gone.
So leave it and have a trust on the person who is constituting a board to make it workable and meet the requirements.
Then we need not have a review board. Then one board is enough.
If they want.
Otherwise, we'll just go on here and there.
No, actually, when I discussed with the doctor, suggesting, suppose there is a board like this, should you have a review board? One viewers don't have a review board because the primary board has taken, that's enough. And the patient has said, allow me to go with peace and dignity. Only thing what the ministry's suggestion was that since you're taking away a person's life, let that thing be reconfirmed by one more, like a review.
Some second balance.
Second.
What you said, that's right.
Why don't you have at least executive instruction pending? Then it will have a status of law.
Take away somebody's life.
Instruction is that there should be 2-tier.
Often that Justice Desai has to say that above me is only God.
Instruction is that there shall be 2-tier check.
So what do you say about this particular clause, 4.4, about the composition of the board?
composition, the instruction what I got is a board comprising of 3 subject experts. That's what they said.
3 subject experts.
Subject experts.
That's that's all that the court was also
Yeah.
said.
It's
Subject expert means who? What subject?
depending upon the
Relevant to the
illness.
patient.
Illness.
Relevant to the patient.
You put subjects and all that is critical.
No, relevant to the patient.
Obviously.
Obviously.
You have to trust somewhere the person who will be called upon to constitute the board. He will constitute the board in reference to the subject which the patient demands.
So they will call the anesthesiast, head of the department, and they will call. If it can fall into disuse. I mean, please, there's a public in the situation, mind you.
No, the doctors have repeatedly said you please trust us.
What you're asking us to do, mind you, because it will apply throughout the length and breadth of the country, there will be a lot of people who can be taken for a huge.
Lordship,
Just to be reminded, I'm telling you,
I'm not,
with all respect to you, we are telling you.
yes, but also the point is, this advanced directive is there in multiple countries.
You don't come.
No, I'm just telling you, Lordship.
Don't compare.
No,
I'm talking about the Western countries.
I'm talking about
Where in India it's capable of being misused. That is why they spend so much time.
I'm asking myself, how is a person in Bombay different from a person in London in terms of hospital care? People are coming here for treatment. So I'm saying misuse may be in the villages where the person is illiterate.
This,
And what the doctors are saying is,
Yes, let us hear.
And one more requirement which is suggested was that in the primary board there shall be one gazetted officer who shall actually he should either record his satisfaction that it was being done by the board and he shall be part of that board.
Oh my, that will be adding in.
It is required. That's what they say. Because tomorrow that particular board, if it takes some decision or anything, there must be some kind of authenticity for that.
That is not bringing more bureaucracy. May not be. Will come. What you want about this is what you say about this 4.4.4, 198.4. You are saying what are you saying in place of this? And at least 3 experts.
Yes, 3 subject experts.
Okay.
Yes. 3 subject experts and 1 gazetted officer at least.
that's what I think not just Rastogi suggests very practical.
What we
The
can do-
doctor plus 2 more experts is enough.
2 more experts in the relevant.
Leave it. Just say 2 more experts. Let the doctors apply that. Let's trust the
2 or
doctor.
3 subject experts.
Two.
Subject experts.
2 more
Treating physician
and 2 more experts.
and 2 more.
They have somebody in the
You have to
relevant
keep
field.
in odd number. Board has to be constituted always in odd number.
Yes, so treating physician and 2 subject experts. Leave it at that. Let us see how it works out.
As far as possible.
Of at least 20 years, and that also you want to knock out. Not necessarily 10 years sufficient.
Then why 20? Why not 30? Why not 10?
No, that's what the court has found.
That's what I'm saying. It's not practical. But the reason why we have taken so much
You
of
don't
trouble
find
is,
anyone with 20 years experience in anywhere in India.
but suppose the person is 18 years. The one doctor is 18. Suppose the man of 22 is gone on leave. But
So that are considering our jurisdiction.
yes.
We are not a reviewing court. To what extent we can tinker with the directives,
No, but the point is,
the substantive judgment,
no, the point is,
which is
if it's a board, if it's a medical board, you can always modify the medical board in the light of experience.
so
There is-
where is the
because-
study that
Yes, my
not
affidavit.
workable?
I got 8 pages of affidavit.
That's
So
my
you-
own.
Even the views, number of experts from 3.
He is also an expert. In law with 5 years also equally an expert.
Even one day is expertise.
No, but in fact, there's a Smith said,
At least they are learned friends.
That's right.
With 1 day experience also.
They are learning.
They are learned friends.
no, in fact, somebody said when you say 10 years experience, it is the same 1 year multiplied 10 times. He's not done anything beyond. So that's a part. I'm just saying 20 years was unworkable because sometimes why keep it 20 years? Keep 3
What
experts
is
and
the
leave
view
it.
of the court? 20 years. 20 years. 20 years, what is your view?